appeal in the matter of Tower UK Ltd and British Telecommunications PLC.
Good morning. I think first of all you can assume that we have done our best to read widely, and so don't hesitate to assume that as you go along. Secondly, I assume that you are aware that we're sitting this morning and then all day tomorrow rather than this afternoon. You weren't aware of that?
We were not ready.
Oh, well, neither was I until quite recently. But in any event, that is the pattern. And so please, if you would therefore tailor your time accordingly, I'd be very grateful. Thank you. Also, if you would keep, your first comments to the general, I'd be grateful, because I will write them on the back of here, but I've left my black book and it's coming. So I'll start on the back of this piece of paper.
Yes, if it pleases your ladyship, your lordships, I appear on behalf of On Tower Limited, the appellant, my learned friends, Miss Toes and Miss Hemans, appear on behalf of the respondent BT. I'll refer to them as On Tower and BT throughout. My lady, in terms of timing, I agree with my learned friend that I'll have 4 hours, my learned friend will have 3.5, but my 4 will cover a reply, so I suspect we'll be roughly equal in time, though I may go short with a fair wind. We shall see. I make no promises. My lady, my lords, as you'll be aware, there are 3 grounds of appeal, but essentially this appeal splits into 2. The first half is ground 1. That is the point of principle. That is the issue that is of, we say, industry-wide importance. And that is the question as to whether a site provider, and I will go through some of the terminology in an overview in a minute, that's where a site provider, a licensor or a landlord, whether they need to comply with the contractual preconditions or the contractual requirements in their lease or license or code agreement in order to exercise a contractual break effectively as an anterior gateway through to Part 5 of the code, which deals with renewal and modification, as we will see, or whether, as my learned friend says, that the contractual provisions are relevant only for the question of timing, for the date that needs to be specified in the paragraph 31 notice, that's the notice for termination under Part 5, and that the contractual preconditions effectively fall away. We'll look at her case in a bit more detail in a minute, but in a nutshell, that's the first half of the appeal and the point of principle. It's agreed also, if you're against me on that appeal, the second section doesn't arise, but in respect of, if you're with me, then we get to Part B, which are grounds 2 and 3, and they are what I would call the site-specific or notice-specific issues about whether, because in fact a separate contractual notice was served in this case, and the question as to whether, which were obiter findings inevitably down below, as to whether the notice was in fact valid. And as you'll recall, my lady, my lords, the issue there starts with a procedural irregularity, which is accepted was irregular and improper, which was a reliance on evidence that had been withdrawn and wasn't relied on. But the effect of that and what your lordships, your ladyship should do about that remains in dispute, and that will be the second half. Just to remind my lady, my lords, the issue, the result we seek, obviously allowing the appeal, is primarily a remission back to the Upper Tribunal to determine that second question in light of the determination of this court on the first question. I'll move straight on then to Part A, which is effectively ground 1. My intention is to give an overview. I appreciate my lady's indication of the ability to go through it, but I will give an overview of the code, because I'm conscious it's something I deal with day in, day out, and I appreciate you may be rather thankful you don't necessarily have to deal with it day in, day out. So I'll go through that, but I'll deal with that to try and avoid or minimise repetition as part of this first section. The first point I want to deal with really is the policy underlying the code. And the code itself, we'll need the authorities bundled to hand if possible, please. The code itself is a self-contained statutory regime, and it is intended to regulate between 2 categories of persons, operators and site providers. That's the terminology used. And operators are those designated by Ofcom with a statutory purpose of one of two things: either the provision of an electronic communications network or the provision of an infrastructure system that benefits the public, on which electronic communication providers can append their apparatus.
Do they have to be licensed by Ofcom?
Yes, a lot of Ofcom grants issues effectively a license, yes. Yeah, precisely, my lord, yes. And they're authorised in one of two ways, but the way that On Tower is authorised and what we are here is what's known as a WIP, which is a wholesale infrastructure provider. That is the provider of passive infrastructure upon which then further apparatus is put by what are called MNOs, mobile network operators. They're the Vodafones or the EEs of the world that one would often think of, but also other electronic communication providers such as the emergency services or of that nature. And this code, which is we still call the new code, although it's coming up for its decade, this code was a replacement of the old code, the 2003 code, the terms of which we haven't got before and largely don't need to trouble this court, save to note perhaps two things. Firstly, that WIPs weren't operators under the old code, so the providers of wholesale infrastructure providers weren't operators. That was a deliberate policy change to encourage investment under the new code and the rollout of technology. Secondly, that under the old code, relevant to what Part 5, which we'll be looking at later, is there was no statutory continuation. So the way it worked under the old code is your contractual agreement expired or ran its course, and then there was a status of sort of statutory immovability. You had to go through a statutory procedure to remove, but there was no continuation of those rights or obligations. That is also something new. And in my submission, the way that the code works is effectively a statutory overlay. So one has one's contractual agreement. And indeed, as the court will have seen in its pre-reading, the whole structure of the code is that it designs and encourages parties to deal with things consensually. Indeed, that's often a prerequisite of various stages where imposition proves required. But if that is unsuccessful, then the ability of the courts, and in this case it's usually the tribunals, to impose those agreements between parties. But the starting point is the contract, and then the code provides a statutory overlay over the top of that. Of course, it overrides the contract where necessary, an example being you can't contract out of the code, the clearest example. It was the ability, we say, of operators, but particularly WIPs in particular, to maintain, develop and invest in the infrastructure that was a major part and a critical part of the introduction of the code. And that, the general aims of the code are neatly summarised by Mr. Justice Fancourt, sitting in the Upper Tribunal, in a case of E Limited and Stevenson. We can find that in the authorities bundle at tab 12. And if I could take you in particular to page 193, that's the pagination at the bottom right-hand corner, our pagination, not the pagination of the report.
193.
193, my lady,
Yep.
yes. And in particular, paragraphs 46 and 47. I'm conscious the court will probably have already read these passages, but the key points I'd ask you to note are that Mr. Justice Fancourt rightly summarises that firstly the intention was for broader rights for operators. It was intended to be greater flexibility. There was an intention that there would be lower costs for operators. That's not particularly something we need to worry about today, but there has been much debate and discussion about how that's to be achieved through lower consideration. But effectively, a no network assumption was introduced to strip out the cost or the value to the operator from the cost of doing so, and instead it's the value of what's lost to the site provider. But there was also, as Mr. Justice Fancourt records, particularly in paragraph 47, a respect for the contractual bargain. And for that reason, it has a limited retrospective operation.
Sorry, what's the limit? Do we need to know about retrospective operation?
Only in this respect, my lord, that Part 5, which is the part we're primarily dealing with, doesn't apply. Under the old code, you can have joint or duality of protection under the 1954 Act, which I suspect the course is more familiar with, which is a security of tenure of business tenancies. So you have, if you had your code agreement under a tenancy, it could have 54 Act protection as well as protection under the old code. And upon the Law Commission's recommendation, the new code transitions everyone away from the 54 Act in this way. If you already had a 54 Act tenancy, it remains a 54 Act tenancy. And when it's renewed, it ceases to be a 54 Act tenancy, and the new agreement takes effect as a code agreement. Part 5 doesn't apply to a 54 Act tenancy. So the way you renew your current, your subsisting agreement, we call them, where it was in existence before the new code came into effect, is through the 1954 Act.
All I'm asking is this going to bear upon our interpretation of Part 5 in this case?
Only insofar as, my lord, I'd ask to note two things. Firstly, Part 5 does apply to licences.
Yeah.
And code agreements are both licences and tenancies. And simply, secondly, that that Parliament was intending, although it does have a limited retrospective effect, the reason it was limited is because there was a respect for bargain. There was a particular concern for the bargain struck by parties in advance under the old code to maintain that.
That's what I was assuming. This, of course, is an agreement entered into after the new legislation came into force.
It absolutely is, my lord.
Yeah, so I don't see what retrospectivity's got to do with it.
Very well, my lord.
Unless I'm missing something.
No, well, my lord, the point is simply that Parliament was always alive to the fact there was a need to respect the bargain between the parties. In some respects, it did that in this way. In other respects, we say it did it by other provisions. I'll take you through it in the new code in a minute. But my lord, the only other point I would like to take you to in this decision is just a paragraph 49 on the same page. This is a specific point, which I'll come back to later, but whilst we're here to save time. Mr. Justice Fancourt also records that the purpose of paragraph 30 of the code, that is the paragraph, as we will see, that introduces statutory continuation, was there for the protection of the operator. So we say that's a neat summary of the purposes of the code and the policy considerations underlying and underpinning Parliament's intention when giving effect to it. There is a larger overview which I propose to give you the reference to, but unless your ladyship or your lordships would like to go to it, I don't propose to given time, which is Lady Rose's summary of the code contained in the Compton Beecham decision. We have that in the authorities bundle at tab 13, and starting at page 204 of the authorities bundle, and in particular paragraphs 2 to 31. And what Lady Rose does there is effectively set out various parts of the code that were relevant to that appeal. But she gives a helpful overview that your ladyship or your lordships might wish to look at as well in due course. Now that overview given, well, by both of them, but particularly Mr. Justice Fancourt that we have dwelt on, is consistent with the Law Commission's recommendations. It's important when considering the Law Commission to remember that they weren't asked to produce, and they didn't produce, a draft bill. So, and there were some changes, although not particularly relevant to our concerns today. There were some changes that were introduced between their recommendations and the eventual code as issued. But it's nonetheless helpful to see the mischief or the particular concerns that the Law Commission had identified that Parliament was responding to. And if I could take you briefly to the supplemental bundle, please, we can look at just a couple of passages from that Law Commission report by way of introduction, and in particular at page 287 of the supplemental bundle. Starting at paragraph 1.39 at the bottom of page 287. And about 4 lines down on the right-hand side, we can see it starts, but we recommend a wholly new system for the revised code. And firstly, you'll note they're doing away, as I said earlier, with the current overlap between the old code and the 54 Act that I mentioned. And then it goes on to say the new system incorporates the best features of the 54 Act security of tenure regime, and in particular the continuation of code rights despite their contractual expiry, thus regularising the position of code operators. And it goes on whilst giving landowners the right to remove, for example, and redevelop. The particular care I referenced earlier, my lord, in respect of retrospectivities, also dealt with over the page on page 288 of paragraph 1.43. Really, that just makes good the point I made earlier about a concern for where bargains had been carefully struck. If we turn to the code itself by way of a brief overview then, your ladyship, your lordships, I suspect have seen, it is divided into 17 parts. I'm pleased to say we don't need to go to the vast majority of them. What you have is part one introducing these key concepts that we've already spoken about, such as statutory purposes. So paragraphs 3 set out the code rights. This is in the Authorities Bundle 1, page 5. And so at the top of that page, or in fact just right at the bottom of page 4, we have the code rights. These are the code rights that are granted or imposed. 4 is addressing the statutory purposes, and you'll see at 4b the purposes of providing an infrastructure system. That's what my client on Tower does. And then 5 deals with apparatus, etc. That was the, for completeness, that was the issue below in what was known as preliminary issue 1, which is not subject to this appeal. Which was that effectively that the 4-storey building that is the telephone exchange is land for the purposes of the code, and therefore we do have a code agreement. But that's not in dispute before you. Part 2 deals with the conferral on exercise of code rights by agreement. As I said at the outset, the starting point is an assumption or hope that things can be dealt with consensually. And Part 2, which starts on page 6, does that. Again, I don't think we need to dwell on that. The 2 parts I'd mention, and then we'll focus on Part 5. Part 4 deals with imposition. So if you can't deal with it by consent, Part 4 deals with imposition, which is through a notice service of a notice and then following a procedure before the tribunal. That's about the acquisition of non-consensual new rights, which, as Lady Rose confirmed in Compton Beecham, either is the classic case of an empty site that you want to go on to, but can be a site where you're already there, but it's something entirely new and separate. It's not a renewal and it's not a modification. Renewal and modification of code rights and code agreements are contained within Part 5, and that is with which we are concerned in this appeal, primarily. And if I can take you, what I intend to do is take you through Part 5 by way of overview now, and then obviously when we're looking at the particular statutory wording, I'll go back to those provisions. This is really just to give us a grounding in where we are. So as I said, Part 5, as it sets out paragraph 28 on page 12 of the Authorities Bundle, is concerned with, well, a number of things. And A is the continuation of code rights after the time at which they cease to be exercisable under an agreement. And B, the further part, is the procedure for bringing an agreement to an end. So that's the 2, there are 2 other parts, but these are the 2 parts we particularly are focused on in regards to paragraphs 30 and 31 in particular. Paragraph 29 specifies who it applies to, and I don't think we need to dwell on it. It doesn't apply, as I said, to 54 Act tenancies. It would apply to any new code agreements such as ours. It would also apply to subsisting agreements that were licenses and so couldn't be protected by the 54 Act.
Could I ask a question to show that I've not understood things? 29.2 tells us that Part 5 doesn't apply inter alia to a lease to which Part 2 of the 54 Act applies.
Well, yes.
And then subparagraph 3 says, in determining whether that is the case, you disregard an agreement under section 38A, excluding Part 2 protection under the 54 Act.
Yes.
When I looked at the lease in this case, there was a Section 38A agreement.
Ah, yes.
So does that imply that this is a lease to which part 2 of...
No, my lord.
no, sorry to misunderstand.
No, not at all. Under the 54 Act, there's now a corresponding provision that excludes code agreements, essentially. So when you have a new, and this is common ground. When
So it's not by virtue of Section 38A, it's by virtue of that provision.
Yes.
It's not a part 2. I don't need to worry that there's a shortcut.
My lord, no, there isn't a shortcut, I'm afraid.
I assumed that was the case. But
I have no doubt my learned friend would have
I had to ask.
taken that point over. No, I'm grateful, my lord, for the clarification. No, absolutely. So it's not a code agreement, but that's not simply because it's not because it's been excluded.
No, enough said. Thank you. Sorry about that.
My lord, so if we then focus at paragraph 30, then is the first of the particular provisions we will be focusing on here. This is the paragraph which deals with the statutory continuation of code rights. 30 sets out when subparagraph 2, which is the paragraph that does the magic essentially, and says to what it will apply to, and it's B1 and 2 to which in particular you will want to spend some consideration of. The first is where the right ceases to be exercisable or the site provider ceases to be bound, or 2, the site provider may bring the code agreement to an end so far as it relates to that right. And where that is the case, 2 is engaged, and 2 is the statutory continuation. And it continues the code agreement so that A, the operator can continue to exercise that right. That by that right, it means the code right or rights. And B, the site provider continues to be bound by that right.
In subparagraph Roman 2 in 31B, what does the word may mean?
Well, it's envisaging that this paragraph 30 has to deal with 2 scenarios. It has to deal with the expiry by the effluxion of time, and it has to deal with...
Well, that's subparagraph 1.
It is, and then it has to deal with the determination by the exercise of a break clause or a notice to quit. And may is simply recognising the fact that 30 will be engaged where either it expires by the effluxion of time, or we say where there is a right to break and that right is exercised.
Well, is it as narrow as that? It's entitlement to terminate for any reason at common law as well, sure.
So well, yes, it would also cover a simple notice to quit situation as a common law, exactly. So if you had a periodic agreement where you simply have to give notice,
or repudiatory breach.
Of course, my lord, I appreciate what my lord might question that.
I mean, as I understand it, even in leases, it's now well established you can have repudiatory breach, and we're not concerned only with leases, we're concerned with contractual licenses.
I was going to make that latter point precisely, my lord. That's the other thing this has to deal with, which is 54. It doesn't have to deal with is licenses. That's why it continues the agreement and doesn't continue the tenancy, like the 54 Act does.
So if it comes to an end,
my lord, yes,
repudiatory breach.
My lord's absolutely right. It has to be. However, it comes.
That
to
also
an end.
engages the protection.
My lord, yes, precisely.
Yeah.
Absolutely. And indeed, if there were such a breach, then of course, breach by the operator is one of the grounds that can be relied on in paragraph 31 to deal with the statutory continuation and bring that to an end.
Take a yearly
some breaches,
sorry,
yes.
Some breaches. My lord, yes.
Take a yearly tenancy. Ordinarily, you'd have a right to terminate the tenancy on 6 months' notice expiring on the anniversary date, correct?
You would, my lord. You serve notice. Effectively, you don't want it to renew.
There seem to be 2 ways of looking at the way this code applies to that situation. One is it's simply enough to point to the existence of the right to terminate. The other is, on your case, as I understand it, if it's a notice to quit arrangement, you would have to serve a notice.
You'd serve both notices, my lord, yes. Or one notice might do double duty.
Or one notice under paragraph 31, which is consistent with the exercise of the notice to quit provision.
My lord, precisely.
Yeah.
And then that's the phrase that under the 54 Act is called doing double duty, which is for what that's worth, but that's what we mean by that.
Yeah.
I.e., one notice can do 2 things. It
So-
all can engage contractual.
So sorry. So just so that I'm clear, you were asked what may meant in 31B little 2, and so I've just got your submission.
Of course, my lady, it's this, that there's a right to do so, and that if that right is, so the site provider has the right to do so, and if the site provider does so, we know it won't actually end the code agreement because 32 will kick in. I mean, at the heart of this dispute is the following question, which is where in paragraph 31, as we'll go and see in a minute, and indeed in paragraph 33, it refers to a date at which, but for the paragraph, it would have ended. We say, the question is whether that's because paragraph 30 is operating to continue the agreement, in which case we say a break has to have been exercised, because otherwise paragraph 30 is not needing to do anything, because it's the contract that's continuing the agreement.
Coming back to my lady's question, what I wrote down, your answer earlier on, was it may means there is a right to breach, and that right is exercised.
Yes.
But I think there's a coda to that. You say it can be exercised either by serving a notice to quit or by a para 31 notice, which is consistent with the notice to quit.
Which is compliant.
Have I got it?
Absolutely, my lord, yes.
Well, not just consistent, but is itself effective as a contractual notice.
My lord, yes, sorry, that's why I say I use the word
double duty notice.
A double duty,
has to comply with whatever the contract requires on your case.
My lord, absolutely. So, sorry, I did say compliant probably too quietly, but compliance is exactly right. It has to satisfy that. And
so slightly more than just consistent with.
my lord, yes. The scenario my lord, Lord Justice Holgate proposed to me was a straight notice to quit question. So the only requirement would be a written notice allowing for a certain time frame. Of course, what we deal with both in this case specifically and in writing and in all submissions I would like to address as well, is where you also have other preconditions or conditions that need satisfying either before the notice is served and which need to be satisfied between. Because just to signpost where we're going with that, my lord, if that helps, it is quite common in such agreements to have landlord break options which are conditional upon a number of things. One might be, for example, satisfying an intention to redevelop or an intention to sell, but there's also then where financial contribution has to be made to the relocation costs. I set out in my skeleton, the costs are usually between £200,000 and £500,000 to move these sites. It's not uncommon to find a site provider agreeing to provide a contribution to that relocation cost. An alternative, if you had either a landed estate or a larger portfolio, might be you often have an obligation to provide a different site, or at least to give the opportunity to go on to a different site. And the difference between my learned friend and I in our cases is this. On my case, if you agree to pay £100,000 contribution, you have to pay the £100,000 contribution. On my learned friend's case, you don't have to pay the £100,000 contribution, you just have to show that you have £100,000 you could have given them.
Does typically the obligation to pay the break amount involve an obligation to pay at the time that you give the notice, or at the time?
In my experiences, at the time of expiry.
How can you? So,
or between the two, by the time of expiry, I perhaps should say. By the time of expiry. I mean, in this case, as we'll see when we go through the contract, there's no obligation to pay anything, but there are obligations that kick in after a notice has been served, and which we say are conditions to the exercise of the break. So, for example, under the alteration ground, once a notice has been served, we have an opportunity to provide workarounds, to say, well, you don't actually need us out because you can work here in these ways, or we can temporarily move, for example. And in my learned friend's case, they wouldn't have to comply with those obligations that have been negotiated between the parties. And in our case, they would have to comply with those. And the real issue is this. We say that the way Part 5 is structured, and I'll come back to paragraph 31 particularly in a minute next, is that the contractual provision is the anterior gateway you have to step through in order to get to your right to exercise paragraph 31 and terminate the agreement that will be continued by paragraph 30. And the whole point is we say if the break clause is irrelevant other than for working out the date you can specify in your paragraph 31 notice, paragraph 30 never has to do the heavy lifting. Paragraph 30 isn't doing any continuation in that situation because the contract will simply continue because you've never broken it contractually. If we turn perhaps to paragraph 31, having looked at the statutory continuation of the paragraph 30, paragraph 31.1, this is still on page 13 of the authorities bundle, 31.1, a site provider is a class of code agreement may bring it to an end by giving a notice in accordance with paragraph to the operator. So here the notice is talking about here is the statutory notice, the paragraph 31 notice. Paragraph 2 sets out a number of things that must be complied with.
Just before you move on,
My lord.
does that mean that if you have a valid paragraph 31 notice, that is the instrument which brings the contract to an end?
Well,
Is that what 31.1 is saying?
31, well, yes,
I mean, subject, of course, to the
yes.
to the following regimen, but
Yes, so it will bring, so if you, in our case, you have to obviously either comply with the contractual requirements with the paragraph 31 notice or do so separately or beforehand. But the code agreement will continue by virtue of paragraph 30. The only way to bring it to an end completely is through paragraph 31. Once you serve your paragraph 31 notice, one of two things will happen. If no counter notice is served, then once you get to the date specified, the agreement will simply come to an end. If a counter notice is served by the operator in situ, who wants to say or challenge the right to terminate, then the statutory continuation continues until the tribunal has determined the position. But the tribunal ultimately has to determine the position in those circumstances, and either the paragraph 31 grounds will be made out, and certainly up to the upper tribunal level, it's agreed the date you have to make those out is the date of trial, mirroring what happens under the 54 Act. If you make them out, the code agreement ends. If you don't make them out, then the tribunal has to make a further. Well, then the agreement either will continue, or more likely the site.
Sorry, can I just understand? So the leave aside timing for the moment. If one's just looking at the statutory grounds in subparagraph 4,
Well, yes.
you serve your notice saying intention to redevelop.
Well, yes.
Say, are you saying that you don't need to show that you had an intention to redevelop at the date you gave your notice? You only have to show that you had it when you get to the tribunal later.
Well, there is upper
Have I
tribunal.
misunderstood what you were telling me?
No, my lord. There's upper tribunal authority that says the date you assess the intention is the date of trial. So it is only at the end you have to establish what the intention is. So that is also true for the 54 Act in this way. So so the case is Betty's Cafe, as my lord probably remembers.
Not from personal experience.
That's also helpful. So the way it works is that you have to serve your notice. Now, it does have to be a bona fide notice, at least under the 54 Act, there's authority to that effect. But the date you assess whether you can make it out is the date of trial, and the consequence of that is that for example, the particular development you intend can change. So quite often someone will serve a notice intending to build 2 shops on the site, knock it down and build 2 shops on the site, and if by the date they get to trial, they've decided they're going to do a completely different redevelopment, that's acceptable. It's what do they intend at the date of trial. It's also at that date you assess the time in which it would take for them to be able to when would they need possession to be able to carry on with the development. The same would be true, for example, with regards to planning permissions. So quite often...
Gregson and Cyril Lord, isn't it?
Well, yes.
There's a more recent authority, isn't there? At high level, I thought.
Well, there's a Francis decision. I don't know if you think my lord's thinking. I don't know if my lord's thinking of the Francis decision, Cavendish Hotels and Francis, which was which put a slight gloss on paragraph F under section 30 of the 54 Act, because what it said there is you discount any. Although motive isn't the relevant question, you discount anything you wouldn't otherwise have done if the tenant had left voluntarily. Really, that is an answer to the advice everyone used to give, which was to just raise the floor an inch or lower the floor an inch as a way of ensuring your ground F would succeed. And unfortunately, the Supreme Court's done away with that now. That did also confirm or worked on the basis that, as with Betty's Cafes, the assessment is later.
So you're saying in a nutshell that, if I followed you correctly, the Lands Chamber has followed, in general terms, the lead given by the jurisprudence on the 54 Act. So you look at whether ground C is made out at the time of the hearing.
My lord, yes, that is correct.
And that explains something which was puzzling me, which was the question that was referred to the Upper Tribunal by the first tier tribunal here was the P31 notice valid? And the finding was, yes, it's valid, but the next question is to see whether subparagraph C or D is made out.
My lord, precisely, and actually
that puzzled me, but I now understand why that's not. That second question is not part of what's meant by validity for the purposes of the issue that was being referred.
My lord, no, not for the purposes before you either. If the appeal either fails entirely, or if I succeed and it's remitted and it's determined that there is a valid contractual notice nonetheless, then the next stage in the litigation will be a determination of those 2 grounds specified in paragraph 31. That's currently stated, but that would be the next stage in the litigation. If my learned friend makes them out, then that's the end of that. If she doesn't make it out, then we move on to the question as to what terms to impose on a new agreement. Another phase.
But conversely, the question, if it arises, as to whether contractually the contractual rights of determination have arisen, depends upon the facts at the date of the contractual notice.
Yes, it depends upon the date of the contractual notice. Also, my learned friend's pleaded case below was also that she could make out those grounds as at the contractual break date specified. I can take you to that pleading later. So my understanding was perhaps it needed to be both. But certainly to serve, yes, when you serve the notice, you have to have, if it's an intention base or what your reason is, you assess that at the date of serving the notice. What is the reason you're serving the notice to terminate the lease? Has to be assessed at the date of serving the notice. But whether you can in fact make out that ground, which is, as I've said in my skeleton, a slightly separate question, may fall to be determined at a later date as well, such as the contractual break date.
Well, that depends presumably on the wording of the clause.
It does, and my lord,
and the case law on that subject.
Precisely, my lord.
Not the wording of the code.
No, the code doesn't affect the contractual requirements, absolutely, my lord. And indeed, that's to some extent my precise point here, which is that the code overlays over the top, but one has to deal with both. And so you look at the contract for the contractual requirements, and you look at the code for the code requirements. My learned friend's case is that you rewrite the contract by writing over with red pen the break clause, and you just use it for a question of timing. And otherwise, you only have to look at paragraph 31.
So that does have what strikes me as a slightly curious consequence that you can potentially establish your contractual right to terminate based on an intention at that time.
Well, yes.
And establish your statutory right under 31(4) at a later stage when the two are quite inconsistent with each other.
Well, let me deal with that in 2 ways. Firstly, up to a point, that's correct. It would depend on, obviously, which grounds you were relying on. Yeah. If you were relying on the redevelopment ground, which under paragraph 31, and the alteration ground under the contract, then it is right to say that the nature of the redevelopment you want to do, the nature of the alteration you want to do may well have changed, but what would need to be consistent for both, on my case, is that you would need to have the desire to, an intention to, carry out some sort of alteration or redevelopment, physical work that required possession, essentially. I'm using that as a shortcut, but would require the lease to be terminated. Because that's what's required under the contract, and broadly speaking, that, as we will see in a moment, is what paragraph 31 requires to make out that ground. So there would be a consistency there, but I absolutely accept it might be that you want to turn the Kenton Road Telephone Exchange into a block of flats when you originally served the notice contractually, and that might well be a valid notice if at the contractual date you had that intention, and then at a later date you might pivot to doing not a block of flats but a block of a shopping mall, in which case that would still work. The issue of inconsistency, of course, I said I'd deal with it in 2 ways. The second way I would deal with it is this: that the question of inconsistency, we say, is very pertinent, because we say it's not right that where you are saying in a statutory notice, I need possession, or I need to terminate this agreement in order to be able to carry out some works, and that mirrors to a high extent one of your contractual obligations. We say that is the reason you are seeking to terminate the agreement. Now, whether they can or can't make that out is not something that we know, or that this particular court will be able to determine. It's not actually a case my learned friend relies upon. But my learned friend's case is, as I say, you just ignore the contractual provisions and requirements, and you only focus on paragraph 31. But we say that isn't right. Here, I accept there are particular grounds and there's a scope for inconsistency. But that inconsistency is not entirely, A, uncommon in my submission, because it mirrors what we say happens in practice under the 54 Act. But B, it's perfectly manageable. It's perfectly possible that you serve a notice and you only know at the end of the period. Anytime you've got a condition which falls to be satisfied between the service of the notice and the relevant date, the break date, means when you serve the notice, you do not know if it will be validly exercised. That's perfectly common as a matter of contract, as I'm sure my law will be familiar with. So we say there's no great special surprise about that or particular difficulty, as I'll address in submissions. My Lord, if I can go back to paragraph 31 then, if we could go over the page to page 14, the particular, we've just spent a moment's time talking about paragraph 4, and they are the four grounds of termination. C is the particular one that causes some controversy or excitement in this case, for the reasons we just discussed in respect of redevelopment. Though it's right to note that I think D is also relied upon in the paragraph 31 notice, which was that the imposition test cannot be satisfied anymore. But if we just go back to the paragraph above, paragraph 3 specifies the date you can specify in your notice. And that date has to be 18 months or after 18 months. And then B deals with the particular date, and it's B that we need to focus on during the course of this appeal, or one of the sub-paragraphs we need to focus on. And it deals with two scenarios, much as with my discussion with my Lord Justice Holgate earlier, in a different context. The first half deals with at a time which, apart from paragraph 30, the code right would have ceased to be exercisable. That is clearly covering, we say, the effluxion of time situation, 5-year term has ended, whether license or lease. And then it goes on to say, or at a time when, apart from that paragraph, the code agreement could have been brought to an end by the site provider. That's the key provision which we will have to dwell on as part of ground 1. In a nutshell, we say that my learned friend and the Upper Tribunal below read too much into the word could. Could is simply reflecting the conditionality that comes with break clauses. We know, in fact, of course, that the break clause that is validly exercised won't, in fact, determine the code agreement because of paragraph 30. But we say if my learned friend is right, and that you don't have to use the anterior gateway of the contractual provisions, either at the same time or beforehand, to get into the question of part 5, then in fact it is not a date that, apart from that paragraph, it would have ended, because that paragraph never has to do any heavy lifting. Because if a break notice is simply not necessary and won't do anything, that paragraph isn't doing any work. Paragraph 30 is continuing the agreement, or will continue the agreement, if the break is validly exercised. And in a nutshell, that's our case on that, so I'll return to it later.
Well, in simple terms, B, which, as you say, falls into 2 parts, has those 2 parts reflect the 2 parts we see in 31 subparagraph B.
My Lord, yes.
Which divides between 1 and 2. So,
my Lord, yes.
Where may was one reason why I asked what do you mean by what you understand may to mean in subparagraph 2, finds its way through to the word could.
My Lord, yes.
Yeah.
Absolutely.
And then indeed,
mirrors.
so we see the overall structure. A similar dichotomy, I think, applies later on.
It's in paragraph 33, subparagraph 3, my Lord, yes.
Yeah.
In fact, I was going to skip over 32, it's a counter notice provision we don't need to worry about. 33 on page 15, my Lord, is unsurprisingly...
If I was to ask you the question, what does could mean, it would be the same
It would be the same answer. My Lord, it would, yes, absolutely.
It's relatively simple.
No, my Lord, absolutely. And can I give an example as to the difference between my learned friend and I actually... So
I need to, in due course, understand what the alternative could is.
My Lord, forgive me.
I will need to understand, we will need to understand,
Yes, of course.
in due course, what the alternative could or may is.
My Lord, yes, precisely. If we look at page 15, subparagraph 3, so just paragraph 33, I should have said it, is distinct from 31. 31 is simply about termination, and only a site provider can serve it. 33 can be served by either a site provider or an operator. We see that actually just over the page at the bottom of page 14, 33, subparagraph 1, an operator or a site provider who's a party to a code agreement. The question as to what a party to a code agreement means, I just noticed it as we pass, is going to come before this court on another date. But that's not a controversy we need to worry about today. But there is an operator and a site provider. All my Lord and my Lady need to bear in mind is that it is capable of being exercised by both. So what 33 does is 33 calls for the modification or renewal of the code rights or code agreements. And what we see is in subparagraph 3, the date to be specified there mirrors exactly, as my Lord Justice Holgate already noted, the provisions earlier. And so the date to be specified from that is again, in respect of break clause, as we say, is the bit which says, or at a time when, apart from that paragraph, the code agreement could have been brought to an end. And I make 2 points here. Firstly, we absolutely accept the consistency point. We say they work in exactly the same way. It's about whether the contractual provisions have been used to accelerate, and as I said, this anterior gateway concept, to accelerate through to get you into Part 5, doing the heavy lifting with paragraph 30, and then needing to be terminated. The other point to note is this. If my learned friend is right on the construction, I'll deal with this now whilst we're here to save time later. If my learned friend's right, then the following applies. If you have a 10-year term and a landlord-only break, I'll say landlord, a site provider, could be a licensor operator, it doesn't make any difference, a break at year 5, then on my learned friend's case, the operator can hijack the landlord's break. Because the operator can say, well, the landlord could have terminated this agreement at year 5, and therefore that's a date I can specify in the notice, and therefore I can serve my notice. Whereas on our case, that isn't correct. The operator can't hijack the landlord's break.
I mean, is the simple point you're making that 33.3 is not accompanied by a parallel provision such as we find in para 31? If I'm keeping up with you.
Sorry, Mel, do you mean which provision are you referring to?
We're here in this case because we've got paragraph 31 notices required, and we're trying to see how that interacts with the contractual provision.
My lord, yes.
But when you turn to 33.3, this enables either the operator or the site provider to require new terms to be considered.
My lord, yes.
Consensually, and in the absence of that, presumably by some process of determination.
My lord, yes, through the tribunal.
Yeah. But where you're operating 33.3, you don't have something akin to a paragraph 31 notice, which actually brings the tenancy to an end.
No, that's right, and in fact...
And you're saying if BT is right, that you just focus on paragraph 31, when you're dealing with our present case, that could have implications, and that, and I'm sorry, I'm not putting this very well, but you're focusing on paragraph 31 and not on the contractual terms. That affects the way you operate 33.3.
My lord, I agree up to a point.
Inelegant.
No, my lord, I agree up to a point. That is a horse I would love to ride, but if I can take you to page 16, there is a provision I should probably draw the court's attention to, which makes the saddle less comfortable. Yeah. Which is, if we look at so 34 is the menu of what the tribunal can do.
Yeah, right.
And if you look at 7, the existing code agreement continues until the new agreement takes effect. So under 34, there's a series of things the tribunal can do. So if I serve a 33 notice...
So can you just... I'm sorry, I misunderstood. Can you just explain to us then, what is your submission? If BT is right,
yes,
then they can... Just make that point again.
Of course,
they can hijack the landlord.
The point is BT here, of course, are the landlord or the site provider. If you've got a 10-year term, and at year 5, the contractual bargain between the parties is the site provider can bring it to an end at year 5, but that the operator cannot. The operator's tied in for 10 years. But if my learned friend's correct, then actually that's not true, because a notice under 33 can be served stipulating a date in compliance with subparagraph 3, because the landlord doesn't have to exercise its break, it simply could have brought it to an end.
That's the point. There's no need to serve the notice.
Exactly. My lord, I think we are talking about the same point, it's just it has a slightly different outcome. It's not that there's nothing continuing the agreement will continue by virtue of paragraph 34, essentially. But what it is that it's an ability for the wrong party to break. So it rewrites the party's bargain, because it effectively means that at day 1 of my 10-year or 15-year term, I, as the operator, could serve a notice stipulating a date that the landlord might be able to break in the future, and then get new terms, or the opportunity for new terms, at that earlier date. And we say, we as an operator say, that cannot be right. The way it's supposed to work is this. If I've got the benefit, then I can exercise, of course, a break, and then I can try and rely on that. But if it's the landlord that has the benefit, the landlord has to have broken. Now, if the landlord serves a break notice, because it wants to get rid of us, we can then serve a paragraph 33 notice, say, no, we want a renewed agreement. That's what we'd like to happen, if we want to. But that's why it's in, that's how that would work. If my learned friend's correct, then you have an operator being able effectively to exercise the site provider's break. And we say that's a nonsense. We have, to an extent, you'll be pleased to hear, exhausted the part 5 to the extent we need to. 34, as I say, gives you the tribunal a menu of what it can do in these circumstances, which I don't think, other than the provision I've taken to you, particularly matters for the issue before your ladyship, your lordships. Paragraph 35 deals with arrangements for effectively interim payments, which is not something that needs to concern this court. And then we move on to part 6. Just for completeness, the way part 6 deals with removal. So part 5 is termination, and then part 6 deals with how you actually get the operator off. Although you'll be pleased to hear there is in fact a way you can then serve a paragraph 20 notice and take yourself back into part 4, but again, you'll be even more pleased to hear we don't need to go through that today. So part 5 is this self-contained regime dealing with modification and renewal. And we are focused on paragraph 31, but to the extent that the same wording is used, we say you have to look at, we're quite happy with my learned friend's point, you have to look at paragraph 33 as well. It's just we say that supports our contention, not hers. What I propose to do briefly now is take you to the contractual provisions.
Would you mind going back to paragraph 32, please?
No, of course. Paragraph 32.
Yes, subparagraph 4. It may not matter, but where the court or tribunal decides that any of the para 31 grounds are established, the court must order that the code agreement comes to in accordance with the order. Could you just explain the words at the end, in accordance with the order?
My lord, yes. So this is where we say, if you've served a paragraph 31 notice that is sufficient to satisfy the contractual requirements, and is also either the same notice satisfies paragraph 31 or you've served a separate, as indeed happened in this case, so they served a separate paragraph 31 notice. If it's a valid paragraph 31 notice, and one of two things happens. The operator either serves a counter notice or it doesn't. If it doesn't, then the agreement will terminate on the date.
Yes, we see that.
If the operator does serve a counter notice, then the agreement continues through until the tribunal determines if those grounds are made out. If one or both of those grounds are made out, then the tribunal will make an order determining the code agreement.
Yes.
If the tribunal decides it's not made out, then the tribunal, one of two things happens. Either everything stays as it was, or particularly if the operator has asked for example, different terms or new terms if it's able to. Because of course this caters not this might cater for an inflection of time. So it might be the agreement simply ended, the contractual terms ended, it's being statutorily continued. And so quite often what happens is you get one party serving a paragraph 31 notice and then you serve a counter notice.
So the short point is this might be a date different from the proposed date of the paragraph 31 notice.
My lord, yes.
Secondly, it gives the tribunal discretion, does it?
I mean, it has to order the
If not, what are
determination.
the principles by which...
It has to order the determination of the agreement.
But does it have a discretion as to what date to order?
And on what terms it's to continue until the date that it chooses?
Well, my lord, I'm not aware of a decision actually having...
No, there isn't.
I don't think anyone's taken... No one's taken my lord's point yet. I'll put it in my back pocket for another day. But the answer is it must make an order to determine it. It must be a date prospectively. It would make no sense for it to be a retrospective date.
One reason why I asked the question is you're about to take us, I think, to part 6, wasn't it?
Well, I was simply going to fly past.
But you might have gone past the proposed date in the paragraph 31 notice by the time these issues are determined. But presumably the tribunal might have a discretion as to what date to set, having regard to the time it takes to remove the equipment.
Well, my lord, can I make a distinction? So, if I can make 2 points. The first is the scenario you've just outlined is what happened here. By the date of the Upper Tribunal hearing, in fact, the date specified in the notice had passed. Sorry? Or was it just after? Oh, sorry, it was just after. Sorry.
Or maybe we can just focus on the code.
But in terms of the code, it is it is possible, my lord, that it would have to specify a different date, because often it would be determined, I mean, even without an appeal, at a later date.
Yeah.
That's undoubtedly the case.
Okay.
Undoubtedly the case. I mean, it's not uncommon for these notices to be served, and then it takes, I mean, even without an appeal, it can take a significant amount of time for these things to come through. Though I should say a lot of these are now primarily dealt with, in fact, by the first tier tribunal. So that has helped, I believe. But the quantity is also increasing, so that'll be an interesting move. So yeah, the other point I was going to make was just about the distinction. So this would specify when the code agreement would end. It wouldn't specify when the items needed to be removed. Because the code agreement ending is a precursor to, again, that's the gateway that gets you into part 6, which is then a separate procedure you have to go through for removal. So termination and removal are separate concepts under the code and dealt with under these separate self-contained regimes. And for that reason, I don't propose to take you to part 6, because it isn't a relevant regime that you're having to construe. If we can look briefly at the contractual provisions then, I'm conscious that these are set out and no doubt you've had time to read them, but if we could look at them briefly. These are contained in the supplemental bundle. The lease is at 314. My lady and my lords would have picked up, this is done by way of an omnibus lease, so many sites, and then there's a site schedule for the particular schedule. The schedule is at page 355, but we don't need to go to it, I'll just give you the reference. The only two clauses that really matter for our purposes are at page 316, which is the term, and that has a term of years commencing in 2021 and ending in November 2030. It's worth noting just in passing, in fact, On Tower has been on the site for many years, subject to successive tenancies, and this is in fact granted pursuant to an earlier option. But this particular lease is granted for that 9-year period, just under 10-year period. The other key clause then, of course, is clause 5.8, which we find at page 340 in the supplemental bundle. It's a long and detailed clause. I propose to dwell on some parts far more than others. But if we start with 5.8a(1), it specifies that if the, and my lady and my lords will be obviously familiar with this having pre-read, but if any of the individual premises you want to terminate, you have to serve prior written notice in accordance with 5a(2). That deals with the timing, which I'll come to in a minute. And then deals with the right to terminate. So you need to have a desire to terminate. It has to be in circumstances in which one of the landlord's termination rights apply. And as I said, it has to be a written notice. 5.8a(2) deals with timing. And in short, if it's one of the 4 specific grounds, it has to be 12 months notice. If it's the general rights, then it has to be 1 month more than the requisite period. I should say there's no issue here about the actual period specified in the notices. But the point here to note is that they are different periods depending on which ground are relied upon.
It's 13 months for 5, is it?
Effectively. In this case, yes, but it could have been different depending on the position, but yes. If we turn over the page to page 341, there are the definitions of alter and dispose. Then there is the landlord's termination right, and this specifies those 5. The first is where there's a disposition to a third party, and the definition of dispose includes an agreement.
But does that, on your case, does that arise only if there is a disposal which has either taken place or has been agreed, rather than a mere intention to dispose?
Well, the way we say it works is this, and I think this is true between both parties, but my left hand correct me if I'm wrong later. The question that has to be asked contractually is what's the reason you're trying to terminate? And if the reason is because you're seeking to make such a disposal, then that's the ground. You can't rely on the general termination right. It doesn't mean you necessarily can make out that termination right. But
5.8a says a landlord's termination right has to apply. We're looking for one,
yes,
whether at a particular time, contractually,
yes,
that termination right applies.
Yes. And we agree with the Upper Tribunal it doesn't apply here because there was an option to surrender rather than a contractual obligation to do so, which is what the Upper Tribunal found.
So in other words,
effectively,
you agree that 1 only applies where there is an existing agreement or there has been a disposal, not where there's a mere intention to dispose.
We agree that in order to rely on that ground, that would have to be the case, my lord, yes.
And how does that then fit with the qualifications to that right which you get in C with direct competitors and portfolio disposals?
Well, my lord, I think the answer to that is about what it goes back to the point I made earlier about my learned friend's pleaded case, which I think we accepted, which is the date you assess whether so you have to serve a notice, you then have to deal with C. I agree that what's contained in subclause C in terms of those things, but it's only at the break date you would be able to tell whether you had satisfied the requirements. Because it's at that date that you would know whether you had, for example, complied with the obligations in C, paragraph, well, C1.
This may not involve a break date at all. This may simply be, I'm terminating for ground 1 disposal.
But it will involve a break date.
If it only means I'm terminating under this ground, I'm only entitled to terminate on this ground because I have already concluded an agreement to dispose at least, or actually dispose.
Yes.
How do you get the protections under subparagraph 1? Because you could presumably just avoid those protections by saying, I haven't yet disposed, I'm not going to sign the agreement till tomorrow.
Well, my lord,
one doesn't apply.
Well, my lord, it's for this reason, that when you serve the notice, the reason you're serving it is to effect such a disposition. The fact that you haven't contractually, at the date of service of the notice, contracted to do so isn't itself a problem, because you also have to be able to satisfy that ground at the break date. There will be a break date because you will have had to specify, you will have had to give your written notice. So the way it's due to operate is you serve your notice that says I want to terminate this agreement on the basis that I intend to make such a disposition.
But why can't you say I want to terminate it today?
Well, you can't say I want to terminate it today, because under the previous page 340, under 5.8a Roman numeral 2,
I see.
you'd have to give 12 months notice.
It's got to be 12 months.
Oh, yes.
I follow.
But C Roman 1 for the portfolio disposal, that's the qualification, isn't it? On the exercise of Roman 1.
There is a qualification for that, yes. Well, it's about, the first thing is they have to make a inquiry, effectively, to check that it's not a direct competitor. And following that, yes, if they can't then affect it to a direct competitor if it's a portfolio.
But that protection for the operator doesn't involve any participation by the operator in that process. It's something the landlord has to satisfy.
My lord, I absolutely agree.
So that would be consistent, going back to my lord's question, with, for example, an outright disposal rather than an agreement to dispose,
Yes.
which is compliant with C, because all that process has been done before you serve the notice.
It could be done beforehand, or it could be done after. I absolutely accept that, my lord.
So that would be consistent with applying the tests in Roman 1 and C1 as at the date of the notice.
Well, yes. If it was a disposal you'd already contracted to do, yes, you could still satisfy it, as long as that position was the case. Of course, what the operator needs to do in those circumstances is be able to verify that's the position.
Verify, yeah.
Absolutely. Yes. Some of these, as we will see, some of these conditions require active participation of the operator as part of its protection. Some of them, it's simply a verification. And a disposal, I absolutely accept as a verification. If we go over the page to 342, well, sorry, so the second on 341.
Is the way you're approaching one that you could operate the clause in that way, but alternatively you may not have a disposal in place as at the date of the break notice, but you've got 12 months within which to verify that you fall within the terms of the break notice clause.
Well, my lord, I think the Upper Tribunal has already determined that where you've got an option to surrender, which is effectively what BT has here,
There's no agreement.
there's no agreement, since that doesn't satisfy it.
Yeah.
And that means you can't rely on that ground.
That's the short point.
Yeah, and we'd accept that position. My Lord, if we look at the alteration on 341 still, so this is under the Roman numeral 2 of landlord's termination right, the alteration to all or any part of the site is proposed, and it would be impeded by the use of the premises for the permitted use, i.e. use for other telecommunications. And if we look over the page of 342, Roman numeral 2 there gives you the requirements of what has to happen for that over and above the giving of notice and the having of such an intention. And essentially, as you'll see, it's a procedure where, one, there's a sort of minimum interruption that needs to be required. You need to be off for a long period of time. But secondly, also, there's an opportunity for this is one, my Lord, where the operator has to engage, or has the opportunity to engage, has to be given the opportunity to provide workarounds. And this is a key one, not only because we say this might be an intention that BT believe they, or they ought to be relying on this ground. We say, or they ought to be trying to rely on this ground. Whether they can make it out or not, we don't know. But that's something they ought to do, as I'll come to when we get to the second half of the appeal. But it's also key because this is an example of a protection for the operator, which, if my learned friend is correct, we would lose. We would lose that protection because my learned friend's client wouldn't have to comply with it. Because the question is simply, could they have terminated, and not did they in fact comply with the contractual conditions or requirements. So this is an example.
Do you mean, could they have terminated by serving a notice?
Well,
which then triggers the...
Well, yes. I mean, again, my case, as you know, is that whether you're doing a 61 notice or 2 depends on the notice requirements. But either way, once you've done that, anything else you need to comply with in order to bring it to an end, you still have to comply with. My learned friend's case, if I've understood it correctly, certainly she ran it below, and I believe it's being run the same here, is that you don't have to comply with those conditions. So, for example, if they could serve only a P31 notice that doesn't tell us which, so the Upper Tribunal found a valid notice contractually had to tell you which of these grounds are specified. But instead, my learned friend says that BT could serve a paragraph 31 notice that does not tell you which contractual ground is being relied upon. So firstly, you've lost the ability to verify or to check until you get to the end point, I suppose. And secondly, that where, such as in Roman numeral 2, there are inbuilt protections, they would not have to do that. They would not have to comply with it. That is my learned friend's case. The absurdity of that position, we say, respectfully, is demonstrated by using other examples, such as if, in fact, a payment needs to be made or another site needs to be shown. My learned friend was absolutely consistent below that what her client would have to show, if it was a £100,000 break premium, they'd have to show that they had £100,000 in the bank that they could have transferred, but they wouldn't need to transfer it. Or if it was an alternative site, there is an alternative site that they could have pointed to, but they didn't need to, in fact, offer it. So that's the distinction between us when it comes to preconditions. Is my learned friend says she simply doesn't have to comply with them, whereas we say she does have to comply with them, because you can only step through that anterior gateway, you can only accelerate the term and the involvement of Part 5 when you have complied with those contractual requirements. They were the two. They were two of the main ones. There are obviously other headings as well. So if we go back to page 341, 3 and 4 specify other particular examples. 4, as an example, is where they cease physically to maintain the whole or any of it, and we see that mirrored over the page of page 342, Roman 3, where if you're relying on the cease to maintain ground, then again two sets of things happen. Firstly, the landlord has to offer to the tenant within 20 days of such a decision the right to undertake for the tenant's own expense such works, physical maintenance. Or B, where the landlord intends to sell the whole of the site, the landlord shall first, by notice, afford the opportunity to make an offer to buy the site. So if you're wanting to rely on that, there's another protection built in, which again, in my submission, my own friend's position would obviate. But back on page 341 then, if you don't, you see Roman numeral 5 then is the general termination right, what we've called the general termination right. And that's where the landlord wishes to terminate the lease, it says to lease, it must be the lease, for any reason other than that set out in those reasons. And that's the general termination right. And that's why we say, and I think my learned friend agrees, you have to look at what's the reason you're terminating. If it fits within one of the other four, you have to rely on that. If it doesn't fit within one of those four, you can rely on the general termination right. So that's the contractual position. Obviously, we've already touched on a number of the points. What I propose to do now is to focus on the particular submissions with regards to my position, but where we've dealt with them.
Sorry to go back.
Of course, my lord.
I understand your last submission about how 5 relates to 1 to 4, but there is this additional question: what if I fail to comply with one of 1 to 4, which might otherwise appear to be relevant? Can I, as a fallback, rely on 5? Say, for example, it's a redevelopment case, an innovation case, and I failed contractually to satisfy Roman 2, see Roman 2.
My lord, yes.
The sort of Heath and Drown type
yes.
argument. Can I then rely on 5?
We say no. We say there's a distinct...
If you can rely on 5, there's not much point having C Roman 2 in the contract.
Precisely. My lord has my point entirely. Precisely. My lord is exactly right, because 5 works. You focus on what's the reason that you want to do it, and that tells you which of the 5 which of the 4 initial gateways you have to try and go through. Now, if you fail to get through one of those gateways, you can't rely on your own failure to bring you within 5. And I should say, my own friend's in her skeleton taking quite a number of what I'd call procedural points. That's not me suggesting they're not important. One of them is she says that's a new comment of ours. It isn't. And I can, if that's a concern, I can take you to where we put it in our original skeleton, because we said all along that you can't rely on your own failure. This issue only arose because, as we'll go through when we look at the second half of the appeal, until 3 weeks before the trial, my learned friend's pleaded case was that the specification in the notice of the general termination right was an error, and that they intended to rely, in fact, on the disposal ground. And then 3 weeks before, they said, well, we do intend to rely on that. Was still what we intended to do, but if we're wrong about that, we can rely on 5. And in response to that, we said in our skeleton and in our opening that that was the position. I can take you to that probably tomorrow, realistically, but I can take you to that when we deal with that part if we need to. But to be clear, we were running that point. And it's quite clear from the interaction between my learned friend and the bench that the bench was also concerned by that, albeit that wasn't how they determined the matter. So if we look at ground 1 then, my lady, my lords, as I said at the outset, this is obviously of the industry-wide importance, and why is axiomatic? Because operators negotiate these contracts at some length and no doubt expense with site providers, and if my learned friend is right, then a significant portion of the negotiations that relate to break clauses is pointless, because the only thing you would need is the date, and you wouldn't need anything else. And we say that cannot be right, either as a matter of Parliament's intention, or we say of approaching the matter with a degree of pragmatism. Our case, as I said, is simply put, and that is that when you read paragraphs 30 and 31 together, and indeed with 33 as well, the terms of a contractual conditional break are not overridden, and they have to be satisfied as the anterior gateway to get you into the opportunity for Part 5. And we have to remember that the Part 5 drafting has to cater for both termination by the effluxion of time, termination by a notice to quit of a periodic arrangement, and then also a fixed term which can be broken on a contractual basis.
And termination at common law.
And as my lord has rightly pointed out, as a termination at common law in some other way, it has to deal with all of these points. Part 5 has to deal with all of those points. Because
and re-entry subject to relief against forfeiture?
Yes. I mean, ultimately, yes. Again, I'm only pausing, my lord, because I can't think of a case where anyone has tried that. But I mean, it must, Part 5 applies. The code agreement would be continued. I don't think the forfeiture could determine the code agreement because paragraph 30 would continue it. So contractually, at common law, it would have ended, subject to relief being granted, but paragraph 30 must still be effective.
No, but if the right to re-enter
Yes.
had arisen
Yes.
and had been exercised...
Yes, it would be such a date. And paragraph 30 would continue the agreement, despite the effect. That must be the case. My lord, absolutely. So, my own friend's case, as I say, is rather different because she seeks a wholesale replacement.
Sorry, and the consequence would be you would only need to give them the minimum 18-month notice.
Then you need to give the minimum 18 months notice, yes. Whereas, of course, if relief from forfeiture were sought and obtained, then you'd go back to the contractual position beforehand because the contract would effectively be restored. Because my lord, of course, I mean, forfeiture obviously, or indeed any termination, right, realistically, even if it's a licence, but where it's akin to forfeiture, but taking forfeiture as the example, the effect, as you'll appreciate, of relief being granted is the term comes back and is backdated and continues as if
Nothing happened.
as if nothing ever happened.
And does that invalidate the notice?
Well, my lord, that's a different case, and one on which I don't have a direct answer for your lordship. I'll be straight.
What happens under the 54 Act when there's a forfeiture of a business tenancy?
Yes, that's true. Yeah, forfeiture is excluded from the 54 Act.
Expressly by
but we
provision.
don't have that here. Yeah.
Yeah.
Okay. My own friend's right.
They were taking,
So I was thinking about the code there, but you asked about
they were taking their cue from the 54 Act up to a point.
Up to a point. Well, that's entirely true. There's no doubt about that. The focus is, and they say they're taking the best bits.
The 54 Act is a curiosity. If you could tell us at some stage, not now.
No, well, my lord, yes, I'll address that when I turn to the 54 Act, perhaps later. Yes, my own friend's case really can be summarised as this. She says it's a replacement regime. She says the effect of paragraph 31 is to, other than for the purposes of dates, is it replaces the contractual regime, whereas we say it overlays across it and sits alongside it. That, in a nutshell, the heart of this dispute is the difference between us on the effect of paragraph 31.
And does this issue hang on the words in paragraph 31, subparagraph 3b, and we look at line 3, at a time when the code agreement could have been brought?
My lord, absolutely. Well, absolutely.
So it comes back in part to at a time, but also what we mean by could.
It does, my lord, absolutely. And in fact, it's fair to say, but below the focus was more on the word could, and that's also what the Upper Tribunal focused on.
Maybe the focus also needs to be on the word may in paragraph 31.
My lord, yes?
1b, and does could mean something different from may when we get to paragraph 31?
My lord, yes, absolutely. As we discussed in Canvas earlier, I agree entirely.
Because the way the analysis seems to be working is that in 31b, on your 31b, under the terms of agreement, Roman 2, sorry, yes, the site provider may bring the code agreement to an end. That begs the question, what's the provision? Is it a notice to quit? Is it a break clause?
Absolutely.
Is it one which depends upon a ground? Could the ground be satisfied, and so on and so forth?
My lord, yes.
But when we turn, on the other hand, and that triggers the continuation provisions, but on the other hand, when you turn to the paragraph 31 notice provisions, which enable the continuation, well, it could be a continuation
Yes.
to an end, on the alternative argument, could selects out of the provisions which represent the break clause,
Yes.
just the timing.
That's what my learned friend says. Yes, she. I think. Well, my learned friend will speak for herself. We'll find out tomorrow. But I think
That's your understanding.
that's my understanding, and that's right. And we say that's plainly wrong because where there are contractual, as we'll now discuss, that doesn't fit with either the policy of the code or there's no justification. In fact, let me go if my lordship's happy with that answer. Or happy enough with that answer. Let me move on to this then.
Sorry, can I just...
Of course, my lord.
So your case is, suppose you have a break clause which is 18 months away, was an entitlement to
Yes.
break on 18 months' notice, and you serve your P31 notice, and you say, under the code, the expiry date is 18 months away,
Yes.
and just for the avoidance of any doubt, although the unexpired term of the lease is another 10 years, I am entitled to determine it contractually in 18 months' time, and that's why the effect of subparagraph B is that 18 months is the appropriate period, and that's the reason I have that contractual right.
Yes.
Nevertheless, if you don't also say, and I'm now exercising that contractual right,
Yes.
you don't, your notice is invalid.
Well, what we say and what we...
Is that your case?
Well, not quite. If all you had to do, if you can, we accept a paragraph 31 could do double duty, where
No,
it can satisfy.
I'm not, my hypothesis is not that it is doing double duty.
Okay.
It is simply, the entitlement exists.
Yes.
It is identified in the P30 notice. It is exercisable at the date
Yes.
of the P31 notice, but it is not in fact exercised in that notice or in a separate contractual notice.
Well,
I think your case is that won't do.
Yes, I'm struggling to see why, if all the contractual requirements were complied with and you were serving a P31, that wouldn't be interpreted as doing both. Just the same as when you have a Section 25 notice under the 54 Act and you...
Would you not actually have to say? Do you not actually have to say? I'm
No, that's
terminating
described as
contractually?
good practice. Because it's usually taken as read that if you're trying to exercise a statutory right to determine and you've got a contract, I mean, in the hypothesis where you don't have to specify a particular ground or satisfy any particular precondition, if you're simply have to give a written notice, then it's usually taken as read that if you're relying on the statutory provision, by serving the statutory notice, you are also seeking to terminate it under the contractual ground, otherwise your notice would obviously have been invalid. So I don't think that question arises in practice, my lord, because it would only really arise where there was some doubt as to whether you could exercise the contractual provision if either there was a, for example, a precondition, that if you had to have formed a particular intention to redevelop, or an intention to sell, or alternatively if there's a precondition such as a contribution financially. Or
But in the
provision of
vanilla
contract.
situation, you're saying that the wording in that P31 will be taken, I can exercise that right, will be taken to be, and I am exercising that right.
Well, yes. I think so. I mean, what actually happens in practice? There isn't.
Sorry, but just pause. Before you go on to what happens in practice, would the same be true if you say, I can terminate for this contractual reason, but you don't say, I am terminating for this contractual reason?
Well, I mean, that would ultimately be a question of construing the notice, but it would be.
Yeah, well, that's,
I mean, yeah, ultimately, if you didn't exercise the break, yes,
Yes.
that is my case. It's just that what happens in practice, that would never happen, because what happens
would
in
it never
practice,
happen?
because what happens in practice is exactly what happened in this case, which is every solicitor, almost every solicitor, would write a covering letter that either says this is also exercising the contractual break, or they literally serve two notices, which is precisely what happened in this case, where they didn't say we're just serving a P31. They served a notice saying they were relying on ground 5, the general termination right. That is what happens day in, day out, and it is the advice in every practitioner. Well, it's advice in the vast majority of practitioner texts under the 54 Act, and it is what one sees in practice.
And so your answer, I think, was if I say I can in the notice, it will be implied that
Yes.
I am.
Absolutely, Melody. I mean, if you wrote a letter that said there's a contractual right to terminate, I'm not exercising that contractual right for the avoidance of doubt, but here's my statutory notice, then we'd say that would be an ineffective notice. You couldn't have said your paragraph 31. But if it is simply a question of giving written notice, and your P31 can provide that, then just the same as under the 1954 Act, we would accept the concept of double duty. We would accept that it would do that.
and what about the case? Sorry, what about the case where it's obvious you do have an 18-month break right, but you don't mention that in your P31. You just simply give your 18 months.
Well, what would tend to, ultimately, if it wasn't agreed, the judge would have to decide whether you could infer from that you were exercising your contractual right. I mean, again, in my experience, the answer would be that the parties would argue about it and then they'd settle it. But almost certainly the judge would see it that you were doing that, because it would be taken as understood that you had to do that.
Well, but the tribunal have said, I think,
Yeah.
in this case,
Yeah.
you do have to specify and identify the contractual right.
Well,
But,
yes.
But you disagree with that, do you?
No, not at all. That's exactly my point. The tribunal, in my submission, gave inconsistent findings, because what they said is, they rejected my learned friend's argument that you didn't have to specify. A valid contractual notice did have to specify a ground. They said that. But then they gave good reasons, cogent reasons for that, such as you needed to know what to verify, as my Lord Justice Holgate discussed earlier, or you needed to know what your rights were and what obligations were owed to you to check whether the conditions were satisfied. But they then go on to say, actually, they agree with my learned friend that all that needed to be served was a P31, and you would just get told at some point in the future. So my case is exactly that they were right to say contractually there had to be a notice specifying a ground that you could rely on contractually. And if they failed to do that, which we say they did, then their P31 must be invalid. But that's because this is a case I absolutely accept and agree with the Upper Tribunal's finding that the contractual notice needed to do that. Where we disagree and where we're appealing is that the Upper Tribunal went on to say that doesn't matter, because all you need to do is do a P31. And a P31, you only need to specify the ground under paragraph 31, not the contractual note. That's exactly my point, that there's another thing we are robbed of. Under the contract, we're entitled to know which of these there are, so that we can verify it and so that we can exercise our rights or have the benefit of those preconditions. But the effect of the Upper Tribunal's decision and the effect of my learned friend's submissions here are that we are robbed of that opportunity.
And so your second acceptance a moment or two ago, it is perhaps not quite right, because you said, well, I think in answer to my Lord Justice Popplewell, well, if it just said we're terminating under paragraph 31, but actually there was an 18-month break clause, it would be for the judge to decide whether you were also, by inference, exercising your 18-month break clause, your contractual break clause. But actually that doesn't fit neatly with having to specify.
Well, my lady, I was answering a hypothetical where there were no contractual requirements, but it wouldn't apply here.
No,
it couldn't apply here. It wouldn't apply here, because here you would have. We know, because the tribunal have found, and there's no appeal of this finding, that if a contractual notice, where one needed, had to specify which ground was being relied upon, and it had to be a ground.
Which paragraph is that? Where they
well, yes. The decision is in the core bundle. It's I think about 104.
I'm not sure they did decide that. So, can we just find the paragraph?
Yes, of course, Mark. If we go to...
was that 101?
Forgive me, it's 101, not 104. Yes.
Because
so
then they say at 102 the response on that point was unnecessary.
Yes, and the reason they say that is because they've already determined that paragraph 31... So what the Upper Tribunal, the point we're appealing, ground one, the Upper Tribunal determined at an earlier stage in the judgment that you didn't need to serve a contractual notice because it's a replacement regime. That's what we're appealing. But so where they say the respondent's argument on the point was unnecessary is because they have already accepted my learned friend's argument below that it's a replacement regime, so you don't need to worry about preconditions, you don't need to worry about serving a contractual notice that complies with the requirements of such a contractual notice. It wasn't necessary. But at 101, they make the finding that a contractual notice, were one required,
I see.
was that. So that's the point, my lord. Absolutely. Well, my lady, I said a moment ago, I'm just going to run through these points. We have covered a lot of them off, so I'll just sort of try and structure them now. In terms of the policy of the code, which is the first big point I would make here.
Going back to an earlier discussion, do you actually have to exercise the break clause as opposed to merely saying I can?
Yes.
If it were in the more straightforward notice to quit situation, where I'm sorry to use that expression, double duty, the paragraph 31 notice, if you're relying upon the notice to quit, is an actual exercise of that contractual provision.
It might well be.
Well, for one thing, under paragraph 31 3b, you have to propose a time which is consistent with the notice to quit provision.
Well, that's a point of
as well as satisfying the 18 months.
Yes, if you can do it the same.
But the simple point is, I don't think anyone would quarrel if you're looking at Skoll and the other case law. It all proceeds on the supposition that you're exercising the notice to quit provision.
My lord, yes, that's
Now,
my
if that is the right way to approach this part of the legislation, it does beg the question: why should it be any different if you're exercising a break clause?
well,
If a break clause is in play.
my lord, yes. There's a couple of answers I might give to that. I mean, to some extent, that supports my position because that's exactly how I say the 54 Act works. In respect of, and exactly what I say about those cases, as you'll see from the annex to my skeleton. But the other answer I would give is this. There is a distinction between a break clause and a notice to quit, which is this. Whereas here you have a conditional break clause, which requires conditions to be satisfied. It's not simply the giving of a notice, either a specific date notice or minimum notice. It's also the satisfaction of other requirements. And that's where the distinction might well arise. And the only 54...
Depending on how you read the code.
Absolutely.
See whether it entitles the tribunal to select just that part of the contract which relates to timing.
My lord, absolutely. And I absolutely agree. That's the distinction between us. We say that is not how it's intended to work, and there's nothing to justify it working in that way, and the language doesn't require it to work that way. That is our case in a nutshell, whereas my learned friend says, no, it's a wholesale replacement regime. The only 54 Act case that deals with the question, with a conditional break, is the Aberdeen Angus steakhouse case, or Aberdeen Steakhouse case, not Aberdeen. Aberdeen Angus is the beef, not the name of the case. Aberdeen steak case, and in that case, it is absolutely clear that Mr. Grabner, QC, as I think he was at the time, sitting as a deputy High Court judge, says you have to do both, and he looks at doing both, and he says it's doing both contractual and not. But that's absolutely right, my lord. But that, in my submission, supports our case. My learned friend is the one who says that the 54 Act works differently to the vast majority of the practitioners' texts, and that actually what it is a wholesale replacement regime, so that you simply ignore the contractual provisions with regards to the break clause, other than for the question of timing. And we say that issue didn't arise in those other cases because they weren't conditional breaks. But in any event...
There's been no 54 Act case with a conditional break.
Well, they only...
Other than
the Aberdeen Steak case, not that my learned friend or I have found, no.
Okay, thank you.
So policy of the code we discussed earlier, and this point is I've already really made, so I'll make it shortly now, which is it's about broader rights. There's absolutely nothing to justify taking rights away. And to give an example, if I had a subsisting agreement that was a license when the new code came into force, before the new code came into force, the landlord or the site provider would have had to comply with those contractual provisions in order to terminate early. And we say there's nothing to justify changing that position, whereas if my learned friend's correct, Part 5 would apply to the licence because it's not covered under the 54 Act, and you would be materially worse off because immediately, overnight, you would have lost the protection of needing satisfaction of the preconditions.
Well, if you've got a break clause with a series of conditional rights, as we have here, but they happen to have different time periods attached to them, and it's just simply a question of timing, does that then enable the landlord to select the break clause which is most favourable to them?
Well,
irrespective of whether or not they intend actually to rely upon that break clause or can satisfy it.
Well, my lord, in my case, no, because in my case they have to have the correct reason. They have to, on my learned friend's case, absolutely. My learned friend's case, on my learned friend's case, she can serve a P31 without telling us.
What I need to understand is just on the basis that the code is said to supplant contractual rights.
Yes.
How much of the contractual rights are supplanted and why?
Well, my lord, that's the distinction. I say the only thing that's supplanted is the fact that the agreement would have ended. That's it. Because that's all that's necessary to give effect to the desire to have a continuation of the code agreement. It's for my learned friend to justify her case, but her case, of course, is that you supplant everything apart from timing. That's the difference between us. or my learned friend will explain if she doesn't accept that, but she'll explain the nicer distinction that she wishes to make. But we say you don't supplant the contract at all, except for the fact that when you have served your break notice and you have complied with your break conditions, in fact, paragraph 30 will continue the agreement. And then it will only, in fact, be determined in accordance with Part 5. That's exactly the point. And we see that is entirely in keeping with the policy of the code, which was to give broader rights. It was facilitative to operators to encourage their investment. And again, taking my example of the £100,000 contribution for site relocation, why does Parliament want the operator not to get that anymore? If that's the contractual bargain struck, that if we get you out early, we will give you £100,000 towards your relocation costs, which will be significant. Why is it Parliament wanted to strip the operator of that? In my submission, it plainly didn't want to do that, and there's no justification for that.
Was the way that point was put before the land stream, the £1 million premium?
Well, it started with £100,000 and then ended up at 10 million. But my lord, inflation took it to 10 million by the end, yes. But my lord, yes, precisely, that is the point.
And can we just see where the Chamber dealt with that?
Yes, of course. So that's contained at, it starts at paragraph 82, which is on page 89 of the core bundle.
But they deal with this in the 88.
And then precisely, it culminates in 88.
Difficult to imagine the circumstances in which a site provider might agree to such. In the face of the likelihood, the payment would be for nothing because of the narrow scope of paragraph 31(4).
Yes.
And the implication, if I understand that correctly, is that it hasn't got to do anything with any of the statutory grounds in paragraph 31(4). So you wouldn't agree to in other words, the promise to make that payment is overridden.
Well,
it supports the submission I think that you're making. That's could be the effect.
my lord, absolutely, that is the effect. And the tribunal,
at least the way the tribunal saw it.
Yeah, precisely, my lord, yes. The difference between the tribunal and me is the tribunal said that because you might have a situation where in order to exercise a break you have to pay £100,000, that's your break premium. The landlord pays that break premium, it contractually breaks, but ultimately they can't make out a paragraph 31 grounds. Ultimately the code agreement continues and is renewed in due course. And they took from that therefore no one would agree to it. Now the reality is that plenty of people do agree to it. And also that we say the answer to that is, but the £100,000 in that hypothetical, my new hypothetical, downgraded for deflation, is that that's the cost of getting you into Part 5. That's the cost of giving the landlord the shot of being able to satisfy one of the paragraph 31 grounds.
Because that's what they've agreed. It doesn't fall within 31(4), it's neither here nor there.
That's a separate question. That's the secondary question. Yeah. My lord, it has the point exactly. That's the cost of getting you there. Whereas my learned friend's case on that, just to remind the court, as I understand it, and certainly as it was run below, is that you do have to show you have £100,000 that you could have given them, you just never need to give it to them. And we say that is an absurd position for Parliament to have intended and cannot be the position. I would, of course, remind your ladyship and your lordships of, in Compton Beecham, Lady Rose, paragraph 106. I'll just find the reference for you. It's at page 224 of the authorities bundle behind tab 13. I think this position is uncontroversial, but it's worth highlighting, which is that the correct approach is to work with the code in particular, which many have commented that infelicitously drafted. Anyone who says that should look at the old code first. But the correct approach is to work out how the regime is intended to work and then consider what meaning should be given to the word. In this case, it was the word occupier that was in dispute. Again, here we say one has to at least ask the question, how is this intended to work? And we say it is not intended to work to mean that operators are robbed of the benefits they contractually negotiate freely for, so that site providers simply have to show they had the money or they had the alternative site rather than complying. We do have the explanatory notes before you. Perhaps if I give you the reference. There in the authorities bundle 1, page 40. They're not terribly illuminating, other than the fact they confirm that the intention was well, perhaps if we go to them briefly, actually, please. Page 40 in the authority bundle 1.
Actually, the logic of what the tribunal is saying in 88 is that there's no point in having any break clause drafted which relies upon a reason for breaking other than the grounds in
My lord, that is precisely the effect, and that, I say, is the curiosity and to some extent the dichotomy created by its own judgment. Because having identified all the good reasons why you need to have a contractual break clause that specifies it and complies, they then go on to say, but you don't actually need to do that. And in my respectful submission, their reasoning was to some extent backwards, because having made the point or reached the conclusion my lord has rightly just made, they then decided, well, that just means no one would agree to that. I mean, they're absolutely right. No one in the future will agree to probably any break clauses, let alone conditional break clauses, if that judgment is right, because there'd be no point.
Well, it's a bit chicken and egg, isn't it? Because
Yes,
in a sense, how you draft leases should perhaps be affected by a correct understanding of the way the code's supposed to operate.
Oh, of course, my lord.
Rather than the other way around.
No, I absolutely accept that, my lord. I'm not suggesting the contrary. I'm simply suggesting that you have to ask the question whether, bearing in mind there was a prior regime, you have to ask whether Parliament intended to effect that change. And in my submission, it did not, for the policy reasons we've already discussed. In terms of the expansion rates, there was some controversy about referring to these, but I understand from a learned friend that's not being pursued. A paragraph, the relevant ones are 425 through to 427.
I'm so sorry, which page?
Forgive me, it's page 4 of tab 1 of authorities bundle. Page 40, forgive me. I'm grateful to my friend. And we see at 45 are dealing with paragraph 30 in particular. What it deals is for code rights to continue as a matter of statute, notwithstanding that they may have come to an end in accordance with their contractual terms. And the point I wanted to note there is terms is plural. It's not simply dealing there with the affluction of time. It's dealing with the fact that it's all of their terms, and we say that includes their break clause terms. So that deals with my policy argument, having outlined the policy earlier, which is simply there's no policy of taking anything away from operators. This is about giving them additional protection. As my Lord Mr. Justice Fancourt said in the Stevenson decision I took you to earlier, the point of paragraph 30 is to give protection to the operator. It wasn't to give that protection in exchange for taking away other rights. There's no suggestion of that anywhere, either in the explanatory notes or in the case law. The second point is a point we've also dealt with briefly, which is about break clauses are about acceleration. They're about the acceleration of the end of the term in a straight contractual position. And here we say it's mirrored again. They're about the acceleration of the opportunity to get through the gateway into Part 5. But if you've agreed that on a conditional basis, we say those conditions must be satisfied. And there's no reason under the code to think otherwise. The third point or argument was the statutory wording. Now, we have already dwelt on paragraphs 30, 31, and to an extent 33. So I don't propose to go through those in detail again. And I think my Lord Justice Holgate, you've already identified precisely the point about how they have to marry up for the effect of them if you limit it to time is precisely what I identified as. And in my submission is simply the decision at the Upper Tribunal really dealt with the wording at paragraph 74 and 75 of its decision. The reference is core bundle page 87. And
what paragraphs?
It's 74 and 75. Well, 73 was where I made the point about my point that it's paragraph 30 that has to do the heavy lifting, the continuation. That's what's envisaged. And it wouldn't be that if you didn't ever have to exercise the brake or engage the brake. And in my submission, the reasoning there, where the Upper Tribunal respectfully went wrong, is their consideration that, well, there's no point because paragraph 30 stops at having effect. That's precisely my point, which is it has to engage, so the paragraph 30 is doing the heavy lift. It's a date when paragraph 30 would be continuing the agreement. If you don't have to engage the contractual break, then paragraph 30 never has to do anything. because the contract does that, the term does that itself. And so my submission, that's where they went wrong in paragraph 74. And when one understands that, and then understands precisely my Lord's point about the earlier word may, and also the conditionality of break clauses, that explains the use of the word could in my respectful submission. And so that's where they go wrong in paragraph 75. In my learned friend Skeleton, she deals with paragraph 33, 3b. 33, my ladyship, your ladyship and your lordships will remember, is where an operator or a site provider can serve notice. And I've already dealt there with that point, which is, if my learned friend's right, then the operator can hijack the landlord's break, and that cannot be right. There's then this principle, which I hadn't understood to be controversial to this case, which is I had understood it would be relatively common ground, that there's generally an intention of Parliament to interfere to a minimum extent with contracts and the freedom to contract. And I cited the Weinberg's case, which is the Authorities Bundle, tab 3, page 56, for that proposition. It is set out in my skeleton in some detail. Sorry, it's tab 3. Well, this was a 54 Act case. And what this case decided was effectively if you serve a contractual notice to break that doesn't comply with the statute, it is effective to terminate the contractual term, but the tenancy continues by virtue of section 24 of the 54 Act in that case. And the relevant page is page 446 of the report and page 65 of the bundle. And it's a highlighted section that we marked to be done, to be pre-read. Forgive me, and it's really these first words by the line on page 65. It does not seem to me necessary, in order to give effect to the act, to give the act the effect which the statute intended, to deprive the landlord of the right to shorten the term in this way. And that we say that's just an example, taken out of the 54, but an example of the right approach to the question, which I think was summarised neatly, if I may respectfully say so, by my Lord Justice Holgate earlier, in saying that the question is the extent to which the code requires you to override the contractual bargain, or contractual terms. And we say the key principle is, and there's no reason for Parliament to want to do otherwise, is to interfere with the contract as little as possible. And we also, that's consistent with an authority my own friend relies on, which is in the Authorities Bundle at tab 10.
Is there a passage in this decision which referred to the principle on which you rely?
Well, as a separate principle, no, my Lord, I absolutely accept that.
You just say by implication that it illustrates the principle?
My Lord, yes. Okay. Precisely. Absolutely, I think. And if we go to the Authorities Bundle tab 10 briefly, and this is the decision of the Crown on behalf of the Child Policy Action Group and the Secretary of State for Work and Pensions. There are a number of relevant passages. If we could start at page 1, well, briefly at page 158, paragraph 27. My lords, this is in fact dealing with about overriding the common law, but it may nonetheless be illustrative, and my learned friend relies on it. Paragraph 27 simply recalls that, and then goes on to discuss in greater detail, which we don't need to concern ourselves with, many examples of where the courts considered whether the provisions of a statute have impliedly overrisen or displaced the common law. And in particular here, the focus is on about available remedies. And my learned friend particularly relies over the page, on page 160, from paragraph 31 onwards. And paragraph 32 starts with the importance of the tax cases as they show that the test is whether, in all the circumstances, Parliament must have intended a common law remedy to coexist with the statutory remedy. And in particular, I would focus over the page at the last paragraph referred to my learned friend Skeleton, paragraph 34 on page 161. About 4 lines down just by the D on the right-hand side. The court should not be too ready to find a common law remedy has been displaced by a statutory one, not least because it's always been open to Parliament to make the position clear by stating explicitly whether the statute is intended to be exhaustive. The mere fact that there are some differences between the common law and the statutory positions is unlikely to be sufficient unless they are substantial. And in my submission, to the extent, my learned friend cites the case, not me, but to the extent that it is relevant to my mind in my submission, the same question can be altered slightly to fit here, which is, in order to reach my learned friend's conclusion, you have to be satisfied that it was Parliament's intention to override the contractual requirements of the break. And in my submission, there's simply no suggestion that was the case, either in the wording chosen by the draftsperson or indeed in anything that preceded it.
This is a slightly different situation, isn't it?
It is, Mark.
This is dealing with whether Parliament overrides the common law, and if you go back to 33, the principle which is in play is the inconsistency principle.
My Lord, yes. No, I accept that. It's just, all I simply say is to the extent that my learned friend
They must cover precisely the same ground, and in the sort of context we're in, I don't think that question arises.
I was simply in response to my learned friend's submissions. I'll move on from that.
As I understand your submission, it is that the code is not intended to interfere with any rights or to diminish any rights of the operator. It's only intended to confer additional rights.
Oh, yes, the focus was to give broader rights, add additional rights, in order to encourage and support investment and rollout of technology. That's precisely the case. Oh, yes. The next point I wish to make was about the practical problems which can arise, but I think we've already covered those in looking both at the contract specifically and also the worked examples I've addressed both orally and in my written submissions in the context of, for example, a provision of identification of other sites, or the provision of a break premium, whether that be a contribution specifically to relocation cost or otherwise. My learned friend, there are there's a particular point I just would address briefly, which is there's also paragraph 100 in the code, which we didn't go to earlier, but we should probably dwell on very briefly, which is, if you go back to the authorities bundle, it's tab 1, and it's page 25. This is contained in part 17 of the code, and it's a provision which is in two halves, and the first half confirms the code does not affect the rights or liabilities arising under an agreement to which an operator is a party. I am going to come to two, I promise, but if I could just dwell on that for a moment. So the starting point is respectful, as I indicated earlier, of the contractual provisions and bargains. Now, it's absolutely right to say, subparagraph 2 goes on to say that subparagraph 1 doesn't apply in relation to, and in parts 3 to 6 of the code as an example. Now, in my submission, this paragraph has to be considered, but plainly is to be read as to the extent that you have, that it mandates it. It's not that one can't read this paragraph as suggesting that Parliament intends for all purposes to override everything in the contract. It has to be insofar as required by those parts. And the classic example is, take the effluxion of time date. The contractual term date is the 1st of September 2025. Well, it doesn't stop it being the contractual term date, but it will be overridden insofar as that won't bring the agreement to an end as it would have done before. So the same with the break clause. We know that paragraph 30 will jump in and do the heavy lifting. And so to that extent, what this really is an anti-avoidance provision. This means you can't have a contractual provision that says you can only renew by exercising a contractual option, or you can, which is on these particular terms with higher rents or higher consideration. You can't have a provision that makes for that, because that would cut across part 5. In many respects, paragraph 100 just begs the question. It doesn't provide your Lordship's relationship with the answer, but what it does demonstrate, I say, is that the starting point is a respect for the contractual bargain, which is encapsulated in subparagraph 1, and then the disapplication in subparagraph 2 must, in my submission, in all common sense, apply insofar as mandated or required by the reading of the code. So it's important just to note that. To the extent, I don't think it will be said, but if it is said that no, subparagraph 2 does more than that and indicates Parliament's rewriting agreements, then I would resist that for the obvious reasons I've already made. The other point that appears in my learned friend's skeleton, which we haven't yet covered in detail, but my learned friend, my Lord Justice Holgate has already addressed it, is the phrase "at a time," which is found in paragraph 31 and also in 33. My learned friend, I might suggest, seeks to concoct a situation where she says it would make it impossible to be able to serve the notices. In my submission, that's not right. The position is as follows in my submission. It might be worth just going to the code, sorry, forgive me, the relevant page. So if we take an example being paragraph 30, subparagraph 3b on page 14 in tab 1.
I'm sorry, so page 14, 31.
Sorry, it's 30. Sorry, 31.
31.
Yeah, did I miss it? Forgive me.
Yeah, 31 4b.
Yes.
Yeah.
Exactly. And the distinction between the phrase after the time and at a time. And my learned friend says that means at a time means that it has to be served to that the P31 would itself expire only at the particular break date, for example, and that if that didn't fit, because obviously 18 months notice has to be given, if that didn't fit, if you had a contractual right that required, that had the concocted position she takes is this. Let's imagine you had a contractual right to terminate in which you had to give a notice of 6 to 12 months, but it could be no more than 12 months notice. So you can only give a 12 months notice contractual notice. And she says that means you could never serve a paragraph 31 notice because the paragraph 31 notice would need to be. In my submission, that's wrong, and it's wrong for one of two reasons. The first is that we say at a time doesn't need to be read that restrictively. It would still be a time when it could have been brought to an end, even if it's after the contractual break date, because that was still, it's not the particular moment that it would have ended. It's a time at when the term could have been ended. We say she reads too much into that provision. But if we're wrong about that, and if in fact the court felt that my learned friend was correct to say that the P31 notice there was one date and one date only that could be specified, then the consequence of that might be that you had to serve your P31 before you served your contractual notice. But the question will still be whether you have satisfied both, so that when your notices expire, have you killed the contract, if I can use that phrase, contractually, so you've still got through that gateway before the 31 is effective on the relevant date provided. And then the question will be, of course, whether you're not. Now, my submission, the first answer is the correct one, but if we're wrong about that, the second would also be workable.
Can I just, I'm not sure I understood that.
Of course.
Take an example where you've got a long period of unexpired term, but you've got a break date, and the contractual provision is that 6 months notice needs to be given of termination at the break date.
And only 6 months.
Not less than.
Not
6
less
months.
than. Okay.
No, not.
Yes.
Not less than. But you can't give it until 6 months. Let's say there's a window of a month either side. So you can't give an early. You can't give an early.
My lord, yes.
So you're now 18 months away from the break date.
Yes.
Is it your case, because at that stage, on the hypothesis I'm giving, there is no contractual right to terminate and you can't exercise the contractual right to terminate. Is it your case that the P31 notice cannot be given until 6 months before the break date, and it then has to be an 18-month notice?
That's my primary position, yes. So I've outlined two arguments. Our primary argument is precisely that, because we say my learned friend imbues at a time when with too much importance or specificity or distinction. So
that gives,
so you can serve...
that gives the operator greater rights than the contractual rights it would have.
Well, it does have greater rights, because it has a right to an 18-month notice under paragraph 31 and the right only to have it determined if they can make out one of the grounds. So we see that's entirely
But in
consistent.
circumstances in which it would be able to say, I'll be entitled to give my contractual notice in a year's time, and I'm going to. Nevertheless, it can't give its 18-month notice at that stage to coincide with what would otherwise be, let us assume, obviously provable,
Yes.
the contractual termination date, so that the site provider gets an extra 12 months, essentially,
My lord, yes,
before the Part 5 code operates.
But you, Mr. Lee, say that's not getting something extra. That is part of the very nature of Part 5, that you're entitled to that 18-month notice period in relation to your code agreement.
My lady, yes, precisely. To the extent I'm getting extra time, that is part of the extra bundle of rights I've been given. And that's absolutely, my lord, is my primary case. My secondary case is if I'm wrong about that, and so the P31 notice can only specify the particular break date and has to use that particular date, it can't use a date falling after that, which I say isn't correct, but if that is the position, then in my submission the answer is that you could then serve a P31 notice specifying a date when you might be able to bring it to an end, and you'll only know if it's effective if you in fact exercise the break in accordance with the terms in the meantime. Just the same as you would serve a contractual break notice and a P31 notice on the same day, knowing that you had to comply with the conditions we say before you get to the contractual break date. So taking my £100,000 example, we're not suggesting you can't serve the P31 at the same time. We're saying that it won't be effective if you haven't served if you haven't paid the £100,000 by the break date, because at that point the date specified in it isn't that date. You'll only know that afterwards, but there's nothing unusual about that. My learned friend points in a footnote in her skeleton argument to the fact you might have to go to the tribunal to argue about whether the notice is valid or not. That's exactly what happened in this case, and that's completely normal in those circumstances. That is not an uncommon scenario. And indeed, taking the intention to redevelop as an example, whether under the 54 Act, under the Code, it's perfectly often the case that you won't, the tenant under the 54 Act doesn't know if the landlord's going to make out the ground F until it gets to trial, or pretty close to trial. That's not unusual, that's not uncommon, it's not unworkable.
Although the tribunal appears to say you ought to be able to determine, the recipient ought to be able to determine whether the paragraph 31 notice is valid at the time that it's given. But you wouldn't agree with that?
Well, I wouldn't. In most cases it will be able to, but I wouldn't agree with that for this reason, because the only way it gets there is by stripping away all of the contractual rights for which the parties have negotiated.
It depends what you mean by knowing whether the notice is valid.
Well, yes.
At one level, you want to be able to tell whether, in terms of formality, the notice contains all that it should do. But in terms of if you've got conditions precedent or subsequent, it may take some time to work out whether they're verified.
My lord, I accept that distinction.
Can I ask, can we go back, I thought what was a straightforward point earlier on. I think you accept that where you don't have this dislocation between 18 months and the period of a simple break clause, 6 or 12 months, you could serve your break clause notice, plus your P31 on the same day.
Yes.
Alternatively, I think you accept that the P31 by itself could suffice to deal with a simple notice to quit case.
Absolutely not.
So is the analysis actually any different if there is this dislocation between 18 months and 6 to 12 months? You could just, if the first proposition is correct, would it not equally apply to the situation where the break notice is exercisable on 6 to 12 months?
My lord, yes, for the reasons,
Well, only if it's doesn't have a...
Yes.
If it's at least 6 or 12 months, you're fine. But if it's if you can't serve an early termination notice, that doesn't work.
my lord's absolutely correct. That's exactly the point. So in the often position, the more likely position where it's not less than 6 months notice or not less than 12 months notice, that no problem arises. My learned friend's hypothesis doesn't arise. My lord, this is Holgate's entirely correct, but my lord is correct that if you do have a unusual or would-be contractual provision that is giving the maximum notice you can give as a cap as well as the minimum notice you can give, then there might well be necessary to serve 2 notices. Just the same as in this case, it would have been necessary to serve 2 notices because we know the contractual notice needed to specify something the statute notice couldn't do. It needed to specify the termination ground you're relying on from clause 5.8, which the statute notice couldn't do. So, my lords, that's I was about to say in a nutshell, but I suppose it's been a rather long nutshell. But that is our case in respect of ground 1 and the interpretation of the code. What then? The only part I haven't addressed yet, and I intend to take very briefly today, both because of available time, but also in part because of its nature, is the 1954 Act and how it works. And it's probably fair to say the way the tribunal dealt with the 54 Act probably mirrored the way it was everyone commented below, which is, well, to the extent it supports my analysis, it's rather helpful, and to the extent it doesn't, it's a separate regime.
Otherwise, it's irrelevant. Yes.
Yes, and I have the good grace, I hope, to respect that, if nothing else. But we say, as I indicated to my Lord Justice Holgate a while ago, that is precisely the way we say that the 54 Act operates. And there are two parts I might just take you to briefly. Firstly, in the practitioner's texts. What I propose to obviously is save some of my time for reply, and it may be I have to deal with the 54 Act more there, because what I'm very conscious of, my lady and my lords, is that this isn't a 54 Act case. And it is also true to say, as we saw from the Law Commission, what it intended to do was borrow concepts, or the best bits, as it were, from the 54 Act, but it doesn't borrow it wholesale, and we see the wording is not, as the Upper Tribunal noted, is not exactly the same. And so it may be that the court feels that whilst the controversy no one really knew existed till my learned friend and I stepped into the Upper Tribunal a year or so ago, it may be that this isn't the forum in which to answer it, albeit I know quite a few people would be delighted if your ladyship and your lordships chose to do so. It's, of course, a question for you. So I do have my annex to the skeleton, which I hope you've seen at the back of the core bundle. That sets out our case in brief. And it mirrors what I say happens under the code, unsurprisingly, which is I say that there is a need to engage with the contractual provisions, and that that isn't limited solely to the question of timing, especially when it comes to preconditions. But as I confirmed to my Lord Justice Holgate moments ago, there isn't a case specifically that addresses that question, where in fact it was argued that you could just ignore the contractual preconditions wholesale. If we look briefly at, say, starting at the practitioner's text, which we've only got two before you, your ladyship and lordships might have been pleased or not to see that there was a list of agreed propositions that we put forward, although you will note some of the agreements are an agreement to disagree, which is only two lawyers could come up with. But we did do our best, I can promise you that. What is clear, and I don't think my learned friend disputes this, as you will have seen, the vast majority of practitioners' texts agree with the concept. I'll use the phrase conscious, my lords haven't liked it too much, but of double duty being required, being capable. The two texts I would just take you to briefly are, one is the Reynolds and Clark passage from the Renewal of Business Tenancies. That's contained in the authorities bundle at tab 14. And if we could look briefly at page 245 of the authorities bundle, paragraph 3202 of the practitioner's text. I don't think anyone would dispute this is the leading text on commercial landlord and tenant renewals. But I don't say that just because both authors are in our chambers, but it may be that it's indisputable. I don't think it is. And what we can see here at 3202 is that if we look about 4 or 5 lines down, I would commend the whole passage to my lady and my lords, but in particular they say, and indeed they cite the Scholl case that my Lord Justice Holgate referred to earlier, often the landlord can serve a Section 25 notice in the prescribed form so as to take effect both as a contractual break notice and the notice under Section 25. And a number of cases are cited there, including the Aberdeen Steakhouse case I referred to, and the Scholl case my Lord referred to. Such a notice must comply with both the contractual requirements of the lease and the statutory requirements of Section 25. And that is the interpretation. Now, as I say, the cases, it's absolutely right to say, my learned friend points to cases, and I openly acknowledge them in my annex, the language of replacement is used. But the focus there, I say, in all of those cases is about the tenancy, because what has to be remembered is that under the 1954 Act, it's only tenancies that applies to any leases, and the contractual term can be ended either by a fluxion of time or by the service of a break notice. And then it is the tenancy, it's the estate in land that is continued by the statute, by Section 24. And that is a point of distinction between the Code and the 54 Act, because it's right to note, as I said earlier, the Code has to deal with licences. and indeed wayleaves and other forms of agreement. It doesn't dictate the wrapper for your code rights. Its focus is on the substantive, not the means. So we say that's a correct summation of the law. And then over the page on page 246, to answer to some extent the question I had earlier, at the end of the first paragraph, in any event, it's always wise when the landlord is both exercising a contractual right to break and terminating the tenancy pursuant to Section 25, that he should make clear it is the covering letter that his Section 25 notice is intended to serve both purposes. And that is, in my submission, not only wise, but that is indeed the common practice. If it is a straightforward, we've only got we need to give no less than 6 months' notice, they would generally say this is also pursuant to Clause X. If, of course, there was more information needed that you couldn't fit on a Section 25 notice, then you would give that information in a separate notice served at the same time. We can see also at the bottom of the page, the Scholl decision is digested. We say correctly, and given time, I'll do it this way, and then I can respond in reply if need be tomorrow. Second sentence, the Court of Appeal held the notice to quit within Section 69 included a break clause. That's not in dispute. And the date specified, as the date specified, Section 25 complied with the terms of the contract and the requirements of the Act, the notice was good notice, effective to bring the contractual term to an end, terminate the tenancy in conformity with the Act. In any event, the notice coupled with the letter was sufficient. They decided on two bases, in fact. There's also a first instance decision on page 247. These are all in the authorities bundle and the relevant passages highlighted for relationship in your lordship's course. You will have seen them. But at the end, it summarises that in the Keith Bailey Rogers case, that was a first instance decision of Mr. Justice Templeman. It was held that it was clear anyone receiving the notice or alternative notice together with the covering letter could be in no doubt the landlord's desirous of terminating the lease pursuant to the break clause. Section 25 notice was therefore sufficient to do double duty. That goes back to the other point that I made earlier about how these things are often interpreted. Over the next tab is tab 15, which is the Woodfall loose leaf text on the law of landlord and tenant. That has the following, but again, various passages have been highlighted. Of course, we commend all of those to you. If I could start on page 251, which is paragraph 22.043, firstly, it records that distinction I made earlier, which is the Act distinguishes between the tenancy and the contract creating it. And then over the page, at the top of 252, again, the whole passage is relevant, but if we go 5 lines up from the bottom of the first paragraph, it says, such notice will not terminate the tenancy, i.e. the estate in land, but a service will give the competent landlord the right to serve statutory notice. Pausing there, what they're talking about there is if you serve a contractual notice that doesn't comply with a statutory notice. And that's, again, not in dispute. And then it goes 3 lines up from the bottom of that paragraph, it says, it's not necessary to terminate the contract in this way by a separate notice. One Section 25 notice under the Act correctly served and in accordance with the requirements of that section can terminate both the contract and the tenancy. And the cases cited there are Scholl and Commercial Properties and Wood, and it's absolutely right to say that, but again, in those cases, we're not dealing with conditional break clauses. And then when we look over the page where the concept of a break clause is considered, paragraph 22.044, a number of things are said. Firstly, 3 lines down, it's convenient to give 2 separate notices, one terminating the contract and one terminating the tenancy under the Act. But it goes on to say, 2 notices are not strictly necessary. A single notice given in the prescribed statutory form for the actual conditional contract break date and served on the date that satisfies both the contractual provision and the requirements of Section 25 will suffice. And then just dealing with conditionality, it's right to say that in the agreed propositions, the passages we referred to there, none of them address the question of a preconditional condition subsequent. They're just not addressed. It is addressed in Woodfall, though. If we just start at the very bottom, this is paragraph 22.044.1. One line up. Many break clauses are exercised. 22.044.1. It's just at the bottom.
Yes, thank you.
I'm grateful, Lord. One line up from the bottom, many break clauses are exercisable only if certain conditions are satisfied, and they give the example of an intention for redevelopment. And over the page, the landlord will normally be required to fulfil these conditions strictly. The validity of Section 25 notice may therefore depend on the fulfilment of the condition precedent to the exercise of the break clause. And then I commend the rest of that passage to you. In my submission, these are, I'm taking this slightly shorthand because of the nature of the point, but these are correct summations of how the law works under the 54 Act. And the only case, as I indicated, where my learned friend and I think, have been able to identify where there is such a condition in a case and judges looking at the question in any way is in the authorities bundle at tab 8. Which is the Aberdeen Steakhouse case. It's a first instance decision of Mr. Grabner, QC, as he was, sitting as a deputy judge of the Chancery Division. We can see from the highlighted section between E and F on the left of the head note a neat summary of the decision facts, which is there was a break clause exercisable on 6 months written notice, should the landlord desire, so they had to have that intention, to do some works of construction to the building. And there was a letter sent enclosing a Section 25 notice. The letter stated that the notice was served under the Act and under the break clause. Again, as I say, that's what happens in practice. The questions that had to be answered are contained on page 123. And starting in the left-hand column, right at the bottom where the line is, the question is, did they satisfy the condition precedent? So clearly that's, the judge considers that as a question that has to be determined, but also then carrying on to the top of the next, if the commissioners did satisfy it, was the notice valid for both the purposes of Section 25 and the break clause in the lease? So again, the learned judge considered that it needed to be satisfied. And then the substantive decision for our purposes on page 124 over the page. Again, I would commend all of the highlighted sections to your ladyship and your lordships, but in particular on the right-hand side, having determined that there was such an intention, he found that the condition had been satisfied. He notes the following. He says at the top, just above H, he says, I do not accept Aberdeen's arguments. First of all, the notice need not, in order to take effect as a Section 25 notice, also comply with the requirements of the break clause and give written notice of the landlord's desire to demolish. Second, in any event, the notice can and should be read in conjunction with the covering letter. If one reads both documents together, it is, I think, very plain that the commissioners were saying they desire to redevelop the building within the meaning of the break clause. And his judgment is then recorded at K to L. In my judgment, the submission confuses two distinct points. First, as a precondition to the operation of the clause, the commissioners must prove that the requisite desire to do the work on or after that relevant date. And second, in order to operate it, he talks about the notice, and in L, my conclusion is that the covering letter taken in conjunction with the Section 25 notice operated both as an effective break notice as well as a good statutory notice under the Act. We say that the learned judge was applying the law correctly in looking for compliance where, as in this case, and unlike the other cases, there was a contractual precondition which had to be satisfied. As I said earlier, you obviously have my annex which sets out my position more broadly and cites the other cases. I'll reserve to reply if I need to and if the court considers it would be helpful dealing with any of the others in more detail. But I do note that there are a number of points of distinction between the 54 Act anyway. The first I've already said, which is it has to cater for other agreements, non-tenancies. Secondly, the policy is slightly different. The policy under the 54 Act is to give security of tenure to businesses, whereas the policy under the Code was a wider grant of additional rights, as we discussed earlier. It includes the concept of security of tenure borrowed from the 54 Act, but it goes beyond that too, as we have seen earlier.
But it includes the imposition of rights.
For my lord, precisely. Precisely.
With a compensation scheme linked to that.
with a compensation and consideration scheme linked to that. And indeed, so one of the distinctions between the Law Commission Act Parliament eventually enacted was the calculation of consideration, where the Law Commission proposed a market value system. And
ignoring special bid.
yeah, exactly. And my lord, and now what is proposed, now what is in the code is not that. It's a no network assumption. So what you are doing is paying for the use that the site provider can't, what they've lost, as opposed to the value to the operator. And that's one of the key purposes, was to bring down the cost to operators. So
you get existing use value, for example.
yes.
Yeah.
In
As
that
long as it's nothing to do with the network.
precisely, my lord, yes.
Yeah.
Yes. Although again, we have some interesting debates about that coming up in due course, but that is exactly right. So I'm conscious of the time. If I can just summarise briefly and finish ground one, and I'll devote my time tomorrow to ground two, which I can take far more shortly. In my submission, for the reasons I've outlined, it really boils down to this. It's only if my lady and my lords decide and determine that Parliament intended not only to rob operators of rights for which they've contractually bargained, or protections for which they've contractually bargained, but also to lead to this slightly absurd position, which is my learned friend's position, as I understand it, certainly was below, which is that there has to be this sort of fantastical or quasi-compliance, in that my learned friend has to show she could have paid the money, or that she could have satisfied the conditions, and that Parliament somehow intended that to be the question, and that Parliament intended that the Upper Tribunal or the First Tier Tribunal investigate whether they could have done something, but actually stripping away the benefit of that very thing from the party itself. And in my submission, that is an absurdity. It is not what Parliament would have intended, nor is it mandated by the wording in the code. And for those reasons, I would invite you to allow the appeal in respect of ground one, which is the point of principle, and then tomorrow I will, in the time available, address ground two.
Mr. Lees, how are you doing? I mean, you've got ground two, obviously, to deal with.
Yes, I mean, my lady, I think we agreed I've had 2.5 hours this morning.
Yeah.
I anticipate dealing with ground two certainly within an hour,
Right.
which would be 3.5 hours, and would leave me half an hour in reply, which is what I'd intended. And my learned friend would have 3.5 hours, so I'm on time.
I think your timetable, though, assumes we sit till 4:30 or something like that.
I think it does assume that. If
Which
that's
is an assumption.
if that's presumptuous, then I'm
That
sure.
is an assumption that council always like to make, and I don't know where they get it from. Anyway, I'm just, of course, that will be fine, so far as I'm aware. But I was just teasing out from you whether, in fact, you need us to sit, for example, at 10 a.m. tomorrow. By the sounds of it, you don't.
I can be done within an hour plus half an hour, so it's really, I mean, I'm very happy to be led by my learned friend. If she would feel more comfortable you starting earlier, I'm happy to start earlier, but I'm confident I'm going to be done in the time. So
My only concern, I suppose, is that when we agreed my learned friend would have more time, an extra half an hour, I was assuming he might have gone through all of those authorities on the 54 Act that we haven't actually looked at yet. So that all does still remain to be done, and I think will need to be done tomorrow. So if there is a concern about the time at the end of the day, for my part, I'd be just as happy to start at 10, and if we finish at 4, so be it. But
Well,
it gives us a measure of...
No, neither am I.
But perhaps you could identify for me at least which those authorities are, and I could be using some of the court time to make sure I've read them.
We've got in the bundle of authorities a number of authorities. The key ones for my purposes are the 4 Court of Appeal authorities on the 54 Act, which are the authorities in tab 4, Scotland, Clifton, Slimline, tab 5, Commercial Properties and Woods, tab 9, Blunden and Frogmore, and tab 11, Seaman. So those are the authorities that I rely on, and I say, frankly, what they say is clear. My own friend obviously doesn't accept that, so we're going to have to go through that. And then I also want to comment on, I think, the 3 first instance decisions that my learned friend has referred to on the 54 Act, which is Weinberg's, Keith Bailey and Aberdeen. He hasn't taken your ladyship and your lordships to those, but in my submission they do need to be read in order to see what they actually say. And so there are seven cases on the 54 Act there that I will need to now go through, which I hadn't anticipated when I agreed my learned friend could have
Well,
more
if
time.
we read the sideline passages in those authorities, that will help.
Then that will help tremendously.
So I think on that basis, 10:30 in the morning. Thank you.
Very good.
For our table.